My lord, I beg to mention item number 5. I am for private respondent number 2
Yes.
on behalf
Objection.
of the arsenal. I am for petitioner.
So what do you want?
Matter may be released after 4 weeks.
Okay. On the prayer of Mr.
K.
Huh?
Tagar.
Hmm?
K. Tagar.
K. Tagar, learned counsel appearing on behalf of Mr. Arsana.
Arsenal.
Learned counsel person and prayer not been
For
objected.
the upper.
Mr. K. Appa, learned counsel by the petitioner. List this matter after 4 weeks.
Yes. My lord, entry may be continued.
Interim order passed, the later shall continue.
Much obliged.
You record his name also. Yes. Jitado. Present. Additional.
Your Lordship, I'd like to mention item number 31.
Hmm.
On behalf of the petitioner counsel, Mr. K. Tagyang.
31.
Yes.
What is this?
This is basically this is case about land dispute where the Deputy Commissioner Itanagar, under the proceeding 145 CRPC, he decided the title and cut off around 200 square meters.
Okay, on the prayer, Mr.
K. Taja, on behalf of
K.
K.
Taja.
Tagyang.
Learned counsel on behalf of Mr. K. Taja, learned counsel for the petition. And prayer not being objected to by learned counsel to the respondent. List this matter after 4 weeks.
Your Lordship, there's an interim order that may
Interim order passed, the later shall continue.
oblige Your Lordship.
2023 years.
Lordship, I beg to mention item number 7 and 8. Lordship, conducting counsel is a Guwahati based advocate.
7 and 8.
Yes, Lordship.
Yes. Why? There's nothing.
Lordship, he telephonically informed me to take adjournment for today.
What is the other matters? 506 and 606.
My lord, that is not listed.
It's an offshoot of that,
Correct, ma'am.
saying that there's a violation of the order of in this case.
Yes,
So why it should be listed together?
my lord.
What happened to the NIT?
NIT, my lord, that has been projected and work has also been awarded to the some other part.
So what remains there?
Yes, no. They are apprehending that the security amount will be appropriate.
Terminated earlier that the work the tender, country has been terminated already.
Terminate.
Lordship, I have no knowledge of the brief.
Okay, on the prayer, Mr.
P.D. Nair.
P.
P.D. Nair.
No, your name.
Or Ditali.
You are not P. Nair.
No, sir.
Huh?
No, sir. No, Lordship.
Your name, please.
Ditali.
Learned counsel appearing on behalf of Mr. P.D. Nair, learned counsel for the petitioner. Submits that the Mr. Nair, learned counsel has some personal difficulty for which he prays for listing of the matter after
Lordship, after 3 weeks.
3 weeks. Mr. Prayer not being objected to, Mr. M. Kato learned DJ, learned counsel for the respondents. Same is allowed list accordingly after 3 weeks.
Yes.
Yep.
Obliged.
Same order in I-8. Huh?
Your Lordship, I am appearing on behalf of Mrs. N. Dange. I would like to mention item number 23.
23.
Yes, Your
Yes.
Lordship, this may be listed after a week.
Is listed for orders. We'll see. We'll see. You be there.
Pardon, Your Lordship.
You be there. We'll see. This is listed for orders.
Yes.
You be there. We'll see what orders. you get.
Your Lordship, I would also like to mention item number 30. This may be listed on 3rd of November.
Why?
Your Lordship, I have been instructed by my senior.
Yes, PP. Special PP.
Yes, SIT. Also, status also there.
So what happened?
Status.
There is sumoto case by the High
No,
Court.
actually, it is a revision against the discharge of the accused person.
Sir, connected matters, there is a sumoto
Oh,
pending before the, I think, principalship.
I have no idea.
It's a lynching matter.
Yes,
Lynching.
lynching matter. Mob lynching.
You find it out,
Yes.
can this be listed along with those sumoto matters?
Yes, SIT standing
Second
consequence.
of matters. Huh?
SIT special PP is also there.
Who is SATPP?
Lomak Karduk.
Yes, you inform.
I live in Pum.
You find out what's happening there in that case. Yes.
Appearing on behalf of the.
Kurdu.
Yes, yes, good.
So, anything you want to say?
See,
Anyway, on the prayer of Miss MS so-and-so, Learned Council appearing on behalf of Mr. MS Dangan, Learned Council for the petitioner, list this matter after respondents, list this matter after 3 weeks. Mr. M. G. Tado, Learned Additional PP, and Mr. So-and-so appearing on behalf of Mr. L. Kurdu, Learned Standing Council, SIT, are present. Yes.
Okay.
May Lordship,
Hmm.
Lordship, with the consent of opposite party, I beg to mention item number 13, Lordship.
313.
Yes, Lordship.
Yes.
Here I'm appearing on behalf of High Standing Council, Titagum, Education Department, Lordship.
Yes.
The matter may list after 2 weeks,
Mr.
Lordship.
Deori, your matter, item 13. So
My lord, they have,
you are running the school now.
yes, school is done.
Therefore, you have no problem.
No, my lord, actually.
On the prayer of Mr. So-and-so, Learned Council, appearing on behalf of Mr. T. Tagum, Learned Standing Council, Education Department, and prayer not being objected to Mr. S.K. Deori, Learned Council for the petition, let this matter be listed after
2 weeks, Lordship.
2 weeks.
Yes.
2
My
weeks.
lord, I also beg to mention, my lord, item number 6, and on
Ye-
behalf of
Obliged, Lordship.
Yes.
Mantau, my lord, he just told me he's not well.
Okay, on the ground that Mr. C. Mantau, Learned Council for the petitioner is not keeping well, comma, Mr. S.K. Deori on the instruction, on the request made on his behalf, submits that matter may be listed after 4 weeks.
And there
List
also one
accordingly after
here,
4 weeks.
Item 29.
Ah,
This may be taken out after 2 weeks. RFA.
what is this, RFA?
This RFA is against the appeal, that time, past appeal.
I know it's a first effect. What's problem with the order of the trial court?
No, my lord, this all evidence has no, the land is under my occupation. But there is a discrepancy in the evidence.
Who will say that if the decree or the order is against you, will say that with regard to the ownership and possession, who as an appellant, who will say that it's not in my possession
No, it is,
or it's not my land?
it's my land.
Will say so. On the prayer of Mr. S.K. Deori, Learned Council for the petition. Appellant, list this matter after 6 weeks. 6 weeks,
Done. That's it. 4 weeks.
4 weeks. Huh?
Apply.
Lordship, with concern of the petitioner council, I would like to mention item number 4, criminal petition number 2, criminal petition number 223, 2023, on behalf of leading counsel for the respondent Subu Koyam, as the leading counsel is out of station due to medical emergencies. And
On the
his,
ground that Mr. S.K. Learned Council for the respondents is engaged in medical emergency. Mr. So-and-so Learned Council, on the consent of Learned Council for the petition, submits that praise for listing of the matter after 4 weeks.
after sir, 1 week.
Huh?
1 week.
1 week. Huh? List accordingly after 1 week. Huh?
Thank you, Lordship.
Your Lordship, I beg to mention item number 1.
Hmm.
I'm appearing on behalf of leading counsel Elban, Your Lordship. This
Hmm.
matter may be listed after 2 weeks.
On the prayer of Mr.
M. Tasoye.
List this matter before any other appropriate bench without.
My lord, interim may be continued. Interim may be continued, my lord.
Continue. This will not be listed before this court. Any other appropriate bench
Obliged.
without me.
My lord, I beg to mention item number 9.
Your Honor, I'm appearing on behalf of leading counsel Miss Emi Talum. So she is,
So land counsel for the petitioner. On the prayer of land.
Your Honor, earlier interim was passed granted, so that may be continue.
Airport petitioner.
Yes, sir.
Oh, so, huh? Appearing on behalf of Mr. MS
Miss
A. Talab.
yes.
Emi Talab, huh? List this matter after 4 weeks. Interim order pass, let's continue. That's what.
Obliged.
Item number 2.
Well, the basic challenge in this read petition is relating to the impugn order dated 7/8/2022 at page 73 passed by the Learned Deputy Commissioner. The fact, in short, my lord, before I indulge my lord or burdened with the annexures, is that the petitioner father was in occupation of the land, and thereafter he applied the land allotment that was not considered, and thereafter passed away in 2017, and again he also applied, the land is under possession. Then there was an FIR filed by the petitioner, and the police made a verification. The police verification report says that the petitioner is in peaceful possession of the land, and thereafter, my lord, there was a complaint before the EAC Itanagar. The EAC Itanagar also finds that land is in possession of the petitioner. Now here the role of respondent number 3 and 4, they came in between, had the land allotment, and then when the petitioner, after passing away of his father, was carrying out the maintenance and all, then he was stopped, he was disturbed. But then because of the decision of the EAC, still the land is in possession, and in between the private respondent 4, he comes in by means of gift deed executions and all, and the original landowner whom the land allotment was given was cancelled. Now, my lord, now therefore, the short question involved in this writ petition, my lord, is on one particular point, my lord, whether the Deputy Commissioner can review its power under section 86 of the 2000 Land Record and Settlement Act. The answer is, my lord, he do have the power subject to obtaining approval from the state government, which he has not done. So therefore, this order cannot stand the scrutiny of law. Now, my lord, kindly come to the annexures, my lord. Page 26, my lord.
Page, the impugn order is page?
Last page, my lord, 73.
Here
he has passed the earlier order.
For hearing of the case, all relevant, it says summon only.
No, my lord. Kindly come. Just paragraph 4, my lord. Further, in the interest of natural justice, the order number DC-ICC 12 so and so that is 17/3/2020 is hereby recalled back. He do not have. He did not have the power to recall his own order, because he is the one who, in exercise of the appellate jurisdiction, my lord, has passed the order. That order, kindly come to page 58, my lord. I'll request my lord to indulge 2-3 paragraph only. The fact already has seen, my lord. This is order dated 17/3/2022. My lord will kindly come to paragraph 6, page.
This is on your complaint, this land allotment in favor of the Sri
PJ.
Tadung Padung. Tadung Padung was cancelled.
Cancelled, my lord.
Cancelled. That has been recalled.
It has been recalled.
And it is pending for final decision. Hearing.
But the manner after the limitation period as prescribed in 82, my lord, he do not have the power to recall it. that should be conjunctively read with section 86 of the Land Record and Settlement Act. And my lord, in section 4 of the Land Record and Settlement Act, my lord, defines
It's page 64 is what again?
in pursuant to the order passed by the Deputy Commissioner, the land allotment of the petitioner was cancelled. The respondent number?
It is mentioned,
cancelled.
Tadung Padu has been allotted floor measuring 200 square for residential purpose, and so which was challenged by the Shri Tony sir and Deputy Commissioner directed the understand take necessary step to cancel the loan. In this regard, you are requested to kindly initiate necessary action for cancellation of the decision which was accorded to Shri Tadung Padung for Thereafter?
Thereafter, my lord, then they have filed this representation by the respondent.
DC has cancelled it,
Yes.
but then
Then we filed
on
it.
your own submission,
Huh?
showing
Sorry.
cancellation has to be approved by the,
In pursuance of that 22 order. my lord,
yes, the
the LRSO initiated the cancellation process. of the
cancellation
land
yet to be cancelled.
Yeah.
Now, in the meantime, the respondent had filed a petition,
Correct.
complaint
Correct.
before the DC
Hmm.
that that order has to be cancelled or recalled because she's also claiming that its land has been allotted in his favor, right?
Correct. Now, my lord, will
Filed by
appreciate.
this court has been issued to so and so to cancel the land and order in respect of Anusi, whereas Sonam Yangpo has submitted that the same plot of land has been gifted by Siddhi Tadung Padam. Yes.
Now, my lord, this has to be read conjunctively with page 37.
Who you are in? Where you do? Where do you fit in? Who is Tadung Padu?
He's a third person, my lord.
He said
No.
this Sonam Yangpo.
My
He
lord,
said
it is like
his-
this. The
Sonam
fir-
Yangpo said that he has been gifted by Tadung Padung,
no, but it's
whose name the
before
land
that-
is allotted.
Before that, the first land allotment was given to one lady, Mije.
Huh?
Yapung Mije, the original land allotment holder is Yapung Mije.
Hmm.
And against that land, she tried to make a claim. Then there was a dispute in between the plot number, bungalow number 16 and 17 by Mrs. Dolo. And thereafter, he was dispossessed. And then he played the game, bringing in Tadung Padung. Then he executed one gift deed. Then she also said at the same time, before executing that gift of deed, my lord, she has also made an application for the alternative allotment of the plot to Mije. Now thereafter, my lord, here is a case of mafia only. So here, the Tadung Padung comes in. Then Tadung Padu, pursuant to this judgment, my lord, kindly page 37, my lord. The EACS uphold say that he land is in possession of the petitioner, and thereafter he did not turn up, and thereafter he executed a gift deed, my lord, to this Sonam Yangpo, another man. So this is how, my lord, kind of mafia is going on.
So who are you?
I am the,
What do you fit in?
my lord, I am the successor of my father. That
Who's your
particular-
father?
Tai Hipik is the father.
Has he been allotted the land?
No, my lord. We have applied the land allotment. That
Ah.
I can demonstrate from here, my lord. Kindly come, my lord.
But then you have not been allotted.
I have not been allotted. Thereafter, again, I have made a fresh allotment in 2015, my lord. 2015. But thereafter, this incident came into. So,
During the pendency of the consideration of your application,
Huh.
the what incident?
during pendency, one Madam Mije, she obtained a land allotment order, but she doesn't have
Same plot of land.
no, not against the same plot of land. So there's a Bangla number 16 and 7 of the Niti Vihar, where the minister resides. So there, her occupation was disputed by one Madam Dolo. So then thereafter, my lord, she submitted a letter for alternative. What is the page? Page 43, my lord. In page 43, page 43, bilateral dated 18/12/2003,
Hmm.
and again at 11/03/2011, she wrote for allocation of the alternative plot of land. Now, thereafter, what had happened, in between, the then one gift deed was executed. 2000, 2008.
These are all you place before the deputy commissioner. All you appear there. You place your everything there. Let the deputy take a decision finally. Then you come back if if you are agreed, because it's only recalling of his own order. All right, but then deputy commissioner is yet to finalize. Only status quo to be maintained.
No, but
Whether legally or illegally, who has the valid allotment, it will be decided by the deputy commissioner.
I have one respectful submission, if my lord allows
Yes.
me to assist. See, kindly come to this particular order, my lord, page 37.
Hmm?
Page 37.
Why I should go back to all this thing?
No,
Unnecessary.
my lord, I have a reason why.
It's a writ petition.
That's why, my lord, there is a reason for this, my lord.
Hmm.
Complain after that. That's
Very complicated facts.
no. It's not very complicated, my lord.
Matter is not complicated.
Hmm.
I'll be disposing it off.
No, my lord, kindly
I'll
come.
not go into all this disputed and all those complicated
Pushpa,
facts.
No, not DC, yeah.
Yes,
EAC,
page 37.
EAC Itanagar.
Brief is laws provided by the
37, yes. Now, my lord, the fact my lord has seen. Kindly come to page 38.
Hmm?
Page 38.
Not
paragraph
37.
two.
Not
Yes.
37.
Yes. 38.
Yes.
Measuring 10 into 20, 200 square meter, and it was gifted to Sri Sonam Yongfo on 7/8/2020 before an executive magistrate, and formal transfer of land was yet to be done. And Sri Sonam Yongfo alleged that Sri Donik Tayu was trying to occupy the plot forcefully, and Sri Dana Tadu and Sri Tamuk Tabin, the president and the general secretary of All Arunachal Pradesh Labor Union, stated that the land in question was earmarked for the union office, and stated that Sri Donik Tayu was occupying it forcefully, and also stated that the plot in question belongs to PWD, and showed one FIR copy lodged by PWD assistant engineer, one Sri J. Taba, and the content of the FIR was that some unknown person have demolished the PWD stock. Sri Donik Tayu submitted his written statement that the land in question was occupied by his late father since so many years, and after the death of his father, he possesses the said plot of land without any dispute, and nearly residents would give witness in the support of his claim right over the said plot of land. After hearing them in person and to authenticate the claims and the counter-claim, it was decided to go for physical verification, inspection of the said plot. Physical inspection of the said plot. And a date and time was fixed on 7/9/2020 at 10:30 hours, and directed all interested parties to present on the spot, and accordingly physical site plot were inspected as per the date and time, so and so were present. Now, my lord, the finding. During the course of the site verification, it came to know that the land in question is physical or possession of one Sri Taku Palang, son of Sri Toku Dochi and Sri Donik Tayu since 1994, having semi-permanent resident and plantation on the plot, and many denizens of nearby residents came out there on the spot to substantiate support in favor of the respondent, and they were scolding Sri Sonam Yongfo for obtaining illegal land allotment of others. Sri Dana Tadu and Tamuk Tabin, who represents the labor union, could not show any evidence to claim their rights over the plot. So, what-
Donik Tayu
I petitioner.
and Sri Toku Palang.
Yes,
Which Toku Palang?
adjacent to the resident.
No, there's no issue.
So, madam,
Toku Palang, no issue.
no issue. I don't have any.
You are not concerned.
No, not concerned. So, madam, kindly see department and his junior engineer, as they could not substantiate their stance on the spot.
No,
And-
these are the things, documents supporting you, which will be decided by
No,
the
that-
deputy
that-
commissioner finally.
Milord, I'm referring to this particular document is this.
To show
in-
that you are in physical position
in the
since
physi- no, no.
1994.
1994, I'm in physical position. That apart, this is a proceeding under the Land Record and Settlement Act, Milord.
Yes.
Now, there is a process. Once the magistrate, EAC or ADC has given this judgment, they ought to prefer appeal. They have not preferred the appeal.
But
And-
you have, now you have not been allotted.
No, I'm not allotted, Milord. That's why. It
Have you
is-
been allotted?
No, Milord.
They're
My
not.
application is under consideration.
This is a government land.
This is a
Right.
government land, yes.
It's a government land.
Correct. No, therefore, Milord, what I'm trying to,
So mayor filing or possessing of the government land, you would not have any right,
I,
indefeasible right to be allotted.
with
Okay.
greatest respect,
Now-
Milord, I do
now-
not have the right.
Now, no allotment is given to you.
Correct.
It appears that if somebody has got the allotment wrongly or rightly. Now that is under consideration who is entitled or not entitled, decided by the deputy commissioner. And deputy commissioner, except for recalling his order, you are agreed by recalling of the order which was in your favor
Correct.
by page 167.
No, say 73.
No, 73 is a impugn order.
Therefore, Milord.
Before that.
Yeah.
Before that, you have been, there's an order.
No, that particular, Milord, that the page 38 which we are referring to,
No.
the
It's
status of the land, Milord, status of land
Yes.
in my favor
No,
has
what is
affirmed.
that first order, 58. 58 is in your favor.
58 is also in my favor, Milord.
What does it say? 58?
That affirmed
That was allotted in favor of respondent number?
63, Milord. Hence, the deal also capital is, Milord, A plus operating portion of the
And it says
package.
for cancel the allotment as per the guidelines so and so submitted complaint for allotment being so and so. This is allotted in favor of
No,
this allotment
Three,
cancellation. in-
three, respondent number 3.
Who is
Padung,
respondent?
Padung.
Padung. Talung Padung.
Taluk.
Now, during the proceedings for cancellation, pendency of the proceedings, who has filed one? Sonam Yangpo.
Sonam
Okay.
Yangfo, in between, Milord, that's why I said, Padung Yangfo, he invariably came to know that I
So
cannot
Sonam Yangpo said that this has been gifted by.
gifted by Padung to me. So therefore,
So it is a
now he
decision
has-
by the deputy commissioner. Sir, go back. You have a good case.
no, Milord, that's why,
You've been
Milord,
favored. In the interest of naturalization, so is hereby called back. It has to be decided.
no, therefore, Milord, the question of law emanates from here.
Yes.
The question of law is whether the deputy commissioner has the power to recall its own order or not by the statute. The statute provides that he can recall. However, there is a rider 86 which says he has to obtain permission from the government, which he did not. So therefore,
See, it was not a final order. The
No.
government has not approved their cancellation. It was on the way,
correct.
about to reach destination.
My lord, may I kindly request, allow me to read out this 86, my lord.
No, I'm saying once it is finalized, then only he may not have the right to recall.
No, my lord, there
This
are,
pendency of hearing only.
no, I agree, my lord. Kindly appreciate me one.
Yes,
clause, my
what is the law?
lord. 86, section 8.
Sir, let us not
86.
complicate the issue which is not
No, my lord, my lord,
glaringly not complicated.
no, my lord, I am not making any complications because the EAC, the police report, verification report.
You may not be, but we find it on
Huh.
hearing you, I find it very complicated.
No, my lord,
Yes,
page,
page
page 229,
219,
229, my lord.
229.
Huh.
Yes,
My lord, kindly see 86. He has a power to review.
229.
But section 86, I page 229, old one, I
No, this is new one. This is Arunachal Pradesh land settlement
settlement.
rules. page 89.
229.
No, 229 is something. What is the section?
Section 86, Milord. Mine is old one, Milord. There is a very,
Let us see.
2 volumes are there.
Huh.
86, Milord.
Yes.
I respectfully agree to an extent that Deputy Commissioner has a power to review the order. However, subject to, Milord, kindly come to the deeming provisions, 2. 1 and 2, Milord. Provided that a revenue officer subordinate to the Deputy Commissioner shall, before reviewing an order under this section, obtain permission of the Deputy Commissioner, and the Deputy Commissioner shall, before reviewing any order passed by any of his predecessor in office, obtain the permission of the government. Even if the statute has given him the power, he do not have, Milord. No order, Milord. 2. No order affecting any question of right between private person shall be reviewed except on the application of a party to the proceeding or except after notice to the other party, and no application of the review of such other order shall be entertained unless it is made within 90 days. Now, my lord, kindly see the order which he has passed, the Deputy Commissioner himself, by judgment order dated 17/3/2022, and thereafter the page 73 order is after which month it is? April, my lord. August. So therefore, the statute clearly bars him.
What is the the revenue officer has been defined?
Yes, section 4, my lord. Section 4 of the Act. Oh, yeah, I remember this. Where is this? 3, 4. Section 4, my lord.
Government notices officer may be appointed by the government in this way from the following class of revenue officer.
My lord, I have given description at paragraph 19 of my rate petition.
What is this proceedings? What is the power and function of the revenue officer?
I don't have the rules. My lord, 86, my lord, 2, 4 and 5 may be important for us. Section 86.
Now, what is the power and function of the revenue officer?
Section 79, I think. Section 9 onward, section 79 onward, yes, appeal and revision provisions. Well, section 83 is important. Section 84 is relating to limitations on appeal.
Then it hits you also. Appeals.
Yes.
If such an order is passed by Deputy Commissioner to the government represented by Concerned Secretary.
Judgment is in my favor.
Huh?
All two judgments are in my
No,
favor
this impure order is against you.
against me. Therefore, he do not have the power. He has to obtain permission from the government. Otherwise,
What is the provision?
86(2).
No order affecting any question of right between private persons shall be reviewed except on the application of party to the proceeding or except after notice to the other party, and no application for review of such order shall be entertained unless it is made within 30 days from the date. What is the requirement of permission from the government?
What provided 86(1) kindly come to provided. Provided that a revenue officer subordinate to the Deputy Commissioner shall, before reviewing an order under this section, obtain permission of the Deputy Commissioner, and the Deputy Commissioner shall, before reviewing any order by any of his predecessors in office, obtain the permission of the government. 2.
No,
order-
basically this is this is not a final order.
No, not a,
Except for saying recalling it, it's not a final order.
no,
You will be given opportunity.
no, respectfully, my lord, would even if the order is at initial stage is void ab
Therefore-
initio, it has
Therefore,
to be
you are
cured through
hereby,
the judicial process.
you are hereby directed someone to appear in person or through its pleasures or judiciary on so and so for hearing of the case with all relevant records or things to testify material justice within the case. Further, in the interest of natural justice, hereby call back a status quo to be maintained at the dispute till the, it's a
No, my lord, even in this case also, he has to pass the mandate of section 83. There is a period of limitation. So suppose if he has to take cognizance of a matter, when limitation is provided under the act, that should be accompanied by the limitation petition.
Sir, this is only a summon. You
No,
place, you
Yeah,
place all, you place all these are the grounds which you may take before the deputy commissioner.
my lord, then may I?
Will say summon in the, it's a interim, I mean, interlocutory order.
No, my lord, that cannot be. This interlocutory order is not sustainable for two reasons.
And it is
Once,
summoned
my lord,
only.
No, my lord, this interlocutory order is not sustainable in law for two reasons, my lord. First, the extra assistant commissioner, the EAC Itanagar, has ruled in my favor. Then two, he himself, the same person acting as a deputy commissioner, has different deputy commissioner has passed this order in my favor. Now, then thereafter what happens? The first appeal, the second appeal is there. Section 83 provides the limitations. If the appeal has not been preferred within a period of 30 days, then 90 days. Here, my lord, kindly see, after so many months he has filed.
Where is Sonam Yangpo a party in that case?
No, he was not. He was not there at all.
That's the problem. It's a common basis on the complaint of the Sonam Yangpo. This summon has been issued on the complaint of Sonam Yangpo,
No, my
which is a
lord,
third party.
my lord, kindly, my lord, I respectfully bow down with my lord's view, but at the same time, my lord, kindly see for travesty of the justice and balancing the equity, the procedural propriety which he has committed is to be appreciated. First, you need.
See,
This is a
that's what I'm
summon
saying.
case.
This
Suppose-
one thing, your doors are not shut. You will be given, you have been summoned to appear. You have been, notice was given to place everything before the deputy commissioner. Deputy commissioner, all these grounds which you are making today
my lord, the
in this
answer-
proceedings,
Correct.
you may take all these grounds before the deputy
My
commissioner.
lord, kindly see page, what is page number? Affidavit in reply filed by us, my lord.
Hmm.
In respect of respondent number 2, my lord.
Hmm.
The instant, sorry,
Yes,
it says,
reply.
yes. Reply filed.
Reply.
Reply filed by us in respect of respondent number 2.
Yes.
Last page, my lord, straight.
Hmm.
Sonam Yangpo was earlier party to the proceeding, but he was dropped for these reasons, my lord.
Where it is?
Yes.
Where it is?
Last page, my lord. Page number 8.
Huh.
Eleven 1/2022 order. सेम आदमी पास किया थी। अरे यार डीसी तो सेम वही है ना।
Appeared Tony this council has been known this school copy of
It is not complete the order. He is in our favor, you know, the same person. So,
Yes.
he was dropped from this process.
This
So
is by whom?
therefore,
This is by filed by whom?
this is filed by me only.
When your lawyer say that they are not connected, obviously they will be dropped. It should have been are not connected, is not connected.
But
Is connected with this and therefore their name may be dropped. That is your prayer. In view of the submission made here in Land Council, therefore his name is hereby dropped, except Mr. Tadung Pad.
because the gift deed was not transferred at that relevant point of time.
Now it has been transferred.
Now, thereafter, may I kindly see the
So
conduct.
he has basis. This was dropped in 2022. That point of time, he was not connected. But Mr. Tadung Padung, after obtaining the allotment, he is gifted to Yangpo. And while the allotment of this Yangpo was I mean, Padung was cancelled
my lord, see the conduct.
by
When
the
the
deputy,
matter-
by the deputy
when-
commissioner.
When the matter was in session,
Yangpo was not,
while the matter, my lord, kindly see, while the matter was in session of the deputy commissioner, they have executed this gift of, if at all,
what is
if-
the area?
144 square meter.
144, 200.
Our is 144
Hmm.
and their land allotment shows 200 square meter. So therefore, my lord, kindly see, if somebody, if
See,
a,
problem is, sir, it's not a final order. You have been given an opportunity. All this, I'm not saying that you may not have, you don't have a case. You may have a valid case, you may have the point, you may have the grounds in your favor. But it all has to be agitated and you placed before the
I-
deputy commissioner who will
I-
finally pass this order.
I have no
Suppose
issues.
tomorrow, after hearing you, he may not recall. He may not, this is not a final order. As you are trying to impress that we should not go by the wording and sentence, we said just recall. Should have, I mean,
No, my lord,
suspended it for a time being
No,
instead of recall,
no, my lord,
recalling.
yes, my lord, the wording number one,
Let us not go into the word.
no, the wording recall. Now the question comes from there itself, whether statute has provided him the power to recall or not. Say per se, if I go by the
Oh,
strict interpretation of the statute,
May not be permitted to review its order and
but if review is
violates-
not there, he do not have the power.
whether the, it's yet to be reviewed. That's why I'm trying to point
No,
out.
my lord, kindly see, let us,
It's a summon, clearly said. It's a summon to
I
all the
agree.
parties,
I
all the parties
have no difficulties
for
on this.
hearing will provide you to place every documents and you should,
And
all should be
Then,
given
my
all
lord, kindly expunge the word recall. Because he do not have the power under the statute and this is abuse of the process of the power.
No, see, when you say that equality applies to you, when you say you will not go by the words
No, my
or
lord,
the sentence used, the substance is that it's an interlocutory order pending final determination by the deputy commissioner after hearing all the affected parties, including you.
my
It
lord,
should have been.
no, my lord, kindly appreciate, I am not trying to.
He has not passed in final order,
No, my lord,
reviewing his order. It
whatever
has
is,
not been reviewed. He
I-
only just recall.
whatever is falling from my lord, I respectfully agree to that.
Maybe
but-
he thought that,
The predicament would be, my lord, the predicament would be.
we'll say that it's not a final order. It's
Huh.
just an interlocutory order pending final determination.
And is
That would say-
accordingly, without prejudice to the right of the parties, the word
Obviously,
recall is expunged, my lord.
will not expand it, but we'll say that we'll clarify that since the final determination yet to be said, the use word recall would not have any
Impact.
impact on the final determination.
Correct.
We'll simply clarify that.
That aspect, then, my lord, kindly, so, well, my understanding, my lord,
Yeah.
my understanding, my lord, with greatest respect, my lord, if my lord allow me for 1-2 minutes, just I want to.
It's going to be 1 hour.
I just finish it, then I leave it to my
You
lord.
know,
for-
you know this court.
I understand, my lord, what to do, my lord. I have signed the power on behalf of the client. I have to
Therefore,
present my
if you
case.
want to argue more, we'll fix it for hearing. Admit and fix it for hearing. All right. Because tomorrow you may say that this court has not, has deprived me from submission and
No,
hearing.
my lord, no, my lord, that,
Because I find it,
my lord, I am a counsel who will never,
I find
who
it,
never blames anyone.
no, I'm not saying that you will blame. All right. If you want to submit more, all right, we'll fix it for hearing
No, my lord, kindly,
some other day.
the interpretation is important because to prima facie, to my view,
You are correct. I'm not saying you are wrong. Your submission may be correct. But in facts of the case, it's being a summon. Although the word recall has been used, it will not have any effect. It will not have any effect. Because the deputy commissioner is yet to determine finally.
my lord, kindly what my lord is whatever is falling is,
Yes,
my lord, the answer I find
yes.
is subsection 2, 86(2), my lord.
Huh.
Just allow me to read.
It has not been filed within 30 days.
Yes. No, it's not. No order affecting, my lord.
Huh.
No order affecting any portion of right between parties, private parties,
Hmm.
shall be reviewed except on the application of a party to the proceeding or except after notice to other party. The
So the
notice,
notice has been given.
no, summon cannot be a notice.
It's not even effective.
Party and no application for review of such orders shall be entertained unless it is made within 90 days. So at least procedural propriety, my lord, he ought to have asked him to file a delay condonation application.
That's why I'm saying we'll make it clear the recalling of the order will not have any effect because the deputy commissioner is yet to determine finally. We'll allow all the parties to
Before, my lord,
have this say,
only the issue which
have all your say before the deputy.
only issue which I am having differences of opinion with my lord is that
Ha.
before 90 days, my lord, any appeal ought to have been filed before 90 days. But it is after 2
See,
days.
that can also be raised before them, before the deputy
Correct,
commissioner.
my lord. With that, my lord, kind of, that's fine.
Will not say delay and all those things. Any points, any grounds, any defense.
Fine, my lord.
All the parties are at liberty to take.
Correct, madam. Kindly, I request you for one word, one sentence only, without prejudice to the rights of the parties.
Huh.
The word recall shall, while word recall shall not have bearing on the proceedings
We will see.
till final proceedings.
Yes.
My lord, I am for the respondent number 3 and 4, my lord.
Hmm.
So my only prayer in short, my lord, would be to refer the matter back to the deputy revenue court, my lord, for
I'll think-
disposal on merit, my lord.
Yes.
A valid late allotment, my lord, was cancelled in absence of the.
You're supposed to file the complaint within 30 days or 90 days.
30 and 90 days.
Huh?
Before the EAC, my lord.
Not the AC, this
No.
is
Huh?
90 days.
Yes, 90 days and then.
But
30
my lord,
days.
no summons were issued to us, my lord, to the respondent number 3 and 4, my lord. Although they have shown to have issued, this was received by a fake person against which we have filed a lodge FIR in the Itanagar police station event. So the respondent number 3 is a assistant engineer serving in different parts of Arunachal. So in his absence, all these things
Okay.
has happened.
Before determination, why you have said that you recall your order?
He has recalled the order, Your Lordship, because after this private respondent has submitted an application.
You are required to hear them before before
Private
recalling.
respondent was not there during the course of the hearing. Your Lordship.
Once you recall the order, matter ends there.
But his name was not in the hearing list. His name was dropped, Your Lordship. So he was not there to give him the.
No, we understand. Nobody. You have to look into the provisions of the law. That is the whole problem.
And since notice was not served to the private respondent number 4, Your Lordship, he could not have filed any.
Yangpo.
Yeah, Yangpo, Your Lordship. His name was dropped, and this order was not served to the private
No,
respondent.
drop because you are not connected at that point of time.
That was the submission of the petitioner, Your Lordship.
Otherwise, you are. I
Yes.
mean, the Yangpo was.
Yes, yes, Your Lordship.
Anyway, we are sending back. We'll allow them to place all defense, whatever materials defense. All right. Heard Mr. T.T. Tharalan, counsel for the petitioner. And also heard M.S. R. Basar, the district counsel for the respondent number
1 and 2.
1 and 2, and Mr. N. Pada, learned counsel for
Respondent number 3 and 4.
3 and 4. agreed by the summon dated 17/08/2022. Next para. Issued by the Deputy
Lord,
Commissioner.
My lord, may I, a small request?
Hmm.
Vote number 2, my matter is
Yes.
reaching, my younger is here, my lord.
Capital Itanagar, whereby the petitioner and respondent number 3 and 4 have been summoned to appear for hearing of the case with all the relevant documents of the material facts related with the case. This writ petition has been instituted essentially on the ground that the Deputy Commissioner, while issuing the summon, has recalled the back the order dated 17/03/2022 passed in favor of the petitioner in violation of the provisions of Arunachal Pradesh land settlements. What is that? Land Settlement
Act 2000.
Arunachal Pradesh within bracket Land Settlement and Reports Act 2000. The next para. Brief facts. Sort of unnecessary details is that the petitioner is in occupation of land measuring 140 square meters located. It's a Gada or Gadda?
Gadda colony.
Gadda.
Gadda, yes.
Gada.
Gadda, yes.
Gada colony. DTBR Itanagar. Since 1994, who was initially in occupation of his father.
Your Lordship, it's 1987.
Hmm?
1987.
We have seen someone is 1994. Anyway, 87.
1987.
The petitioner, having been in possession since the days of his father, applied for allotment of the said plot of land before the concerned authorities. Just to list of next para. The no. A dispute arose involving few persons with regard to the said the land located in the vicinity of the land occupied by the petitioner, along with including the land of the petitioner. What is the order of the ESC?
It's page number 37, Your Lordship.
On
Annexure 7.
by an order dated 29/09/2020, the Deputy Commissioner passed an order. No, Deputy Commissioner, after verification on the physical verification of the
Your Lordship, it's Executive Minister come ESC.
no, Assistant Commissioner, Extra Assistant Commissioner, Executive Magistrate, Itanagar Capital Region. After physical verification of the entire dispute, has held that the petitioner along with one Sri Toku Palang are in possession of the land since so many years, thereby allowed to possess hold the said plot of land, and same shall not be evicted without authority of law. Please stop. Next pair. When the matter was were rested on that
Your Lordship, thereafter I filed.
thereafter, what was the dispute again?
Thereafter I lodged a complaint before the Deputy Commissioner
Saying what?
saying for cancellation of land allotment issued
Okay.
in favor of
In-
Tadung Padung.
Please stop.
Page number 47.
Next pair. In the meantime, when the matter was under consideration for allotment, when the regulation, when the allotment, on the application for allotment in favor of, submitted by the petition was pending, comma, the authority has illegally allotted the said plot of land to one city, to the in favor of the respondent number 2.
Respondent number 3,
Respondent number 3, namely Sri Tadung Padung,
Tadung Padung.
list of, against which the by the allotment order is
Sorry, my lord,
Page number 45.
my lord,
Earlier,
that's a wrong submission. my lord.
that
We-
relevant
no,
point
no.
time, Yapung Major was allotted. Thereafter it was transferred to Tadung Padung.
okay, was allotted to one Yapung Mize,
Yapung Major.
which was
Retransferred to
retransferred in favor of
respondent number 3, Tadung
respondent
Padung.
number 3, and namely Tadung Padung,
In 2011,
with the respondent number 2, 3 in the year 2011,
11.
against which the petitioner filed a complaint for cancellation of land allotment order in favor of Tadung Padu before the Deputy Commissioner. Next para. On 1703/20, by an order dated 1703/2022. After hearing the parties and consideration of the matter, the Deputy Commissioner has, where is the operative person?
It's page 63, Your Lordship.
Where I said last vote, whereby? Has held that the allotment order bearing allotment order dated 11/03/2001.
Yeah.
Is 2001
Yes, yes.
Yes. Initial
Since-
allotment.
cancelled and directed the DLRSO Eternal Capital Complex to initiate necessary steps to cancel the allotment officially as per the relevant rules, guidelines, etc. Please stop. Please stop. While the petitioner, while the process for cancellation is per the order dated 17, sorry, 02/03/2022, passed by the Deputy Commissioner. A complaint was received from the, no, a complaint was filed by one Sri Sonam Yangpo, respondent number 4. Praying for cancellation of, revocation and cancellation of the allotment order dated. What is this allotment order? 2704/2022.
It's a lordship, it's a Yapung Majaba transfer to Tadung Padung. That allotment,
I'll not go into that. They call revocation and cancellation of the allotment order in favor of the petitioner and the order dated 17/3/2022. Pursuant thereto, the Deputy Commissioner issued the impugned summon, passed the impugned summon dated 17/08/2022, directing the petitioner and the respondent number 2 and 3 to appear for hearing of the case with all the relevant documents / materials. Mr. Well, the next paragraph. Essentially, the petitioner is agreed by the order, agreed by the order of the Deputy Commissioner, which recalls the order dated 17/03/2022, which was passed in favor of the petitioner. Mr. Next paragraph. Mr. Titi Taralan, counsel for the petitioner, while referring to the provisions of Section 6 of 86 of so-and-so, land settlement so-and-so, strenuously argued that the Deputy Commissioner has no authority to review its own order without the without obtaining the permission with the government. Mr. He submits that as the any order has to be passed, any order of review has to be passed after obtaining the permission of the government. Mr. He further he submits that no order affecting any question of right between the private parties can be reviewed except on the application of the party to the proceedings or after notice to the other party, and no application for review of such order shall be entertained unless it is made within 90 days from the date of the order. Therefore, in the instant case, he submits the use of the word callback of the order that is 17/03/2022 amounts to a review of its own order by the Deputy Commissioner, which is not permissible under the law. Therefore, he submits that the impugned summon, that effort, since no application has been filed within 90 days. Yes, from the, where is this order, complaint?
complaint is annexure. So annexure 12, page number 65. It's 2nd August 2022.
Order was passed.
Order was passed on 17/03/2022. After 5 months.
What I said? After? From the date of the order, dated 17/03/2022. the complaint, public application ought not to have been entertained, as the same is hopelessly barred under the provisions of subsection 2 of section 86 of so and so Act, huh? Christoph. Therefore, he submits that the summons, impugn summons so and so may be set aside. MS Arbasar and Mr.
And power.
N. Pada, learned counsel for the respondents. E-converso, huh? E-converso, this, comma, e-converso, comma, submits, have submitted that the, since the impugn or impugn summon is only for appearance with the all the relevant documents, public materials for hearing of the case on the pursuant to the complaint made by the respondent number 4, who appears to be actually land allottee,
Yes.
comma. There is no illegality in issuing a summon for proceedings of the case. It is submitted that mere use of the word callback would not amount to review of the order, as the impugn summon itself, impugn order itself is a summon for hearing of the matters, and the final determination of the case is yet to be made. Therefore, there's no wrong in issuing a summon to the parties for settlement or final determination of the matter. That's all.
My lord, since they have strongly relied on section 86, my reliance on section 79 may also be recorded. my
What
lord,
is 79?
Because I didn't get sufficient time to make submission, my lord.
Will allow you to make all this submission before the next period. I've considered the submissions of learned counsel for the parties, and also where is the material records, materials available on record, including the provisions of the land settlements, so and so. Essentially, the grievance of the petitioner is to the order of recalling back the order dated 1703/2022, passed by the Deputy Commissioner in favor of the petitioner, to the effect that the recalling of the order is amounts to review, which is not permissible under the under section 86 of land settlements, so and so. Next para. For a better appreciation, it is appropriate to refer to the provisions of section 86, which is extracted here in below, section 86. Perusal of the next para. Above provision shows that a revenue officer may either on his own motion or on the application of any party interested review any order passed by himself, any order passed provided that the revenue officer is if they provided that an order is, a review order is passed by this revenue officer subordinate to the deputy commissioner. Permission shall be obtained from the deputy commissioner, and in case of the deputy commissioner, from the government. It also provides that no order affecting any question of right between private parties shall be reviewed, except on the application of a party to the proceedings, or except after notice to the other party, and no application for review of such orders shall be entertained unless it is made within 90 days from the date of the order. Next paragraph. Admittedly, the Deputy Commissioner, by an order dated 17/3/2022, has cancelled the allotment order made in favor of whom?
Respondent number 3.
Respondent number 3,
Pardon.
which was in favor of the on the complaint of the petitioner, and directed the DLRS Itanagor to process for cancellation, for process the matter for cancellation by the government in terms of the order passed on 17/3/2022. Next para. Please stop. It is also admitted position that the complainant, namely,
Donik Tayo.
no,
Or
Mr.
Sonam Yangpo.
Sonam Yangpo, respondent number 4,
Yes.
herein, was not a party to the proceedings. Were you a party?
His ground was that his ground was that he received a gift deed from respondent number 3. That's the ground.
No, he was a party to the proceedings.
Earlier he was party.
17/2.
Yes, earlier he was a party. He was
17/3 order, he was a party.
Yes. Your Lordship, later on he was dropped from the case.
No, it's okay.
My lord, the respondent number 4 was not a party to
He
the.
was not a party.
Yeah.
Earlier he was party, but it was dropped.
Dropped on your prayer.
Yes, Lord.
And not a party to the proceedings. In case number DC ICC 12016/7/2021, between the petitioner and the respondent number 3. Initially, it appears that the respondent 4 was a party. However, on the prayer of the learned counsel for the petitioner,
Yes, Lord.
the name of the respondent number 4 was dropped. Mr. As per the next para, provisions, an application for application for review of the order cannot be entertained unless it is made within 90 days from the date of the order, and no order affecting any question of right between private persons shall be reviewed except on the application of party to the proceedings. Mr. In the instant case, since the complainant, namely respondent Sonam Yangpo, respondent number 4, was not a party to the proceedings of the order dated 17/3/2022, it cannot be. It would not be appropriate to say that the it would not be appropriate to expect the party who was not party to the proceedings to file a petition or file a application for review within the stipulated period. However, that the such grounds would be a matter to be decided by the deputy commissioner while taking up the complaint of the application as to whether there was a reasonable ground to file the complaint. Reasonable ground to prevent the petition, the complainant from filing the application within the limitation period under the law. Next para. The summon, impugned summon, the impugned order summoning the impugned order dated 17/08/2022 passed by the deputy commissioner summoning the parties, including the petition, the parties for hearing, as reflected in the states, reflected in the summon, to the effect that the parties are directed to appear with all the relevant documents and materials for hearing of the matter. In my considered view, cannot be found faulted, as in issue, the issue involved requires to be finally determined. Thus, the summon per se, the impugned summon per se cannot be held to be illegal. However, the order of recalling ought not to have been passed. Recalling of the order dated 17/03/2022 ought not to have been passed before the final determination. No, the pending final determination, not before, pending final determination. Mr. Considering above, no, in view of that, the using of the word, use of the word, all back within apostrophe, would not have any bearing on the final determination of the disputes oblique matter by the deputy commissioner. What I said? On the proceedings and final determination of the determination by the deputy commissioner. And be not considered as a final and shall not be considered as a final, shall not be considered a review order. Well, finally determining the issue, dispute and dispute between the parties. That's all. In view of what has been discussed here in above, comma. I'm of the considered view that the parties the matter be remanded back to the Deputy Commissioner, Capital Itanagar, for final determination in terms of the summon dated 17/08/2022. List of the parties shall be allowed to place all the relevant documents of materials before the Deputy Commissioner. And the Deputy Commissioner shall hear the matter and decide, hear and decide the matter by providing opportunity to all the parties. That's all,
Yes, Lordship.
Mr. Writ petition stands disposed of
All right.
in terms of that.
Item number 3.
Your Honor, I'm appearing on behalf of Nikita Dange. Your Honor, the existing interim order may be extended till the next date of hearing.
You are appearing on behalf of?
Miss Dange,
Okay.
Nikita
You want
Dange.
some time?
Otherwise, my lord,
Pleadings are complete.
yes, this matter has become infructuous actually because
Okay.
both the lease agreements has been cancelled.
What is the challenge here?
Um,
Challenge is what?
The writ petition has been challenged, challenging the order letter dated 30/08/2022, written to the Deputy Commissioner, East Siang District, Pasigat, by the Deputy Director, Department of Tourism, Arunachal Pradesh, whereby a tourist lodge at Guminagar has been leased out to the respondent number 5 for a period of 30 years.
What is that? 30/08/2022 order is where?
Your Honor,
Page
29.
29. Is a lease order.
yes, Your Honor.
Leasing of tourism assets under East Siang District. Huh?
Yes, Your Honor.
So this has been cancelled.
Yes,
So now it's cancelled.
Yeah.
It has been given to whom? Nobody.
nobody.
No, but
Matter is become infructuous. Heard MS so and so learn counsel for the petitioner. Where is have you annexed the cancellation?
Yes, my lord.
Where it is?
In the additional affidavit at paragraph
And Mr.
17.
And the Y. Ramlani State Council for the Elani State Council and Mr. N. Pada, Standing Council
Yes.
for Tourism Department,
Yes.
representing the Tourism Department. List of the challenge made in this writ petition is to the '29. Communication dated 30/08/2022, whereby issued by the Deputy Director, Department of Tourism, Government of Arunachal Pradesh, whereby tourism assets under East Siang District, namely tourist lodge at Govindagar, and angling club and tourist viewpoint, Komligar. In favor of whom? Huh?
In favor of respondent number 3, my.
Who is respondent number 3?
Oh, sorry, my.
Respondent number 5.
5.
Huh?
Respondent number 5. Yeah.
Respondent number 5. Namely Shri Miriam Komut. What I say? Communication. Tourism assets under East Siang district, huh? Namely, please stop. Mr. Op and Pada, the Understanding Council. Let's the where it is.
Yeah.
Affidavit by
By the tourism department.
respondent number 4.
Yeah.
Yes,
Three.
page
3.
huh?
1, 2, and 3 years.
Tourism department.
Yes.
Filed by whom?
1, 2, and 3.
Page
Page 17 of the additional affidavit.
additional affidavit. Ah, 17.
Yeah.
What does it say?
This is cancellation order.
17, 16, 17 is where it is cancelled.
Additional affidavit, my.
Ha, page 17.
Yeah.
Annexure 1A.
Yeah, one, annexure 1.
It's page 16. Cancellation, huh? I said, the Standing Council, you are referring to the communication dated 25/06/2024. Submits that the communication granting lease to the respondent number so and so in respect of tourist assets so and so has already been cancelled. Therefore, the matter has become infructuous. Are you agreeing to that? You have received the affidavit,
Yes, yeah.
additional affidavit.
Yes.
It has been cancelled, nothing remains.
Mhm.
You try to apply again. In view of the above, and as fairly admitted by the parties, rate petition has become infructuous accordingly. Rate petition stands closed as infructuous.
Item number 10.
Please, your lordship. Osundokha.
This is a fight between the.
It's a huge.
No, Lordship, I'll not take it. Lordship, in the top of the file, there are 5 pages only. Lordship can take that. Lordship can keep the file. I'll satisfy Lordship. Yes, that much.
This one.
Yes. Actually, Lordship, these are not my document. There was an injunction order passed in my favor. There is 10 pages. Then they filed an appeal. In the appeal, Lordship, they filed 1,000 pages. So filing revision, Lordship, I have to annex that. So it is not, I have not filed.
So we'll fix for hearing.
No, Lordship, it is already done. Lordship, last order, Lordship, you can see that the matter will be disposed of today. Lordship, that was the understanding. Last order, Lordship, it was admitted, Lordship. Lordship, this creates a problem, Lordship. Is a student body is here, Lordship. Lordship will not adjourn this matter, I hope, Lordship, because that is why, Lordship, on the last date itself, Lordship, there is an order passed after admission of both the parties, Lordship. Both the parties has consented, and that is how the matter was adjourned on the last date, Lordship.
What is the issue?
Lordship, is a small issue, Lordship. There is a student body called Anshu. They have their branch students union. For the Anshu's election, Lordship, the branch students union will send their representative because the branch students union are the feeder for the Anshu's election. So there are election for the branch students union, there are election for the Anshu's students union election. So Lordship, branch students union will send their feeder and they will vote for the Anshu leader. And so initially there will be branch students union election, then they will send the representative to the central body, and there is a constitution. Constitution has said that how to deal with all this matter, and the constitution in the annex, there is a
Yes, please come.
bylaw, and the bylaw, Lordship, as per that bylaw, Lordship, everything is fixed, Lordship, how to send, how many members will give the vote and the or everything is there in the bylaw. So there is no problem with that.
Yes.
Lordship, initially, Lordship, on 28/1/25, Lordship, I have to admit, Lordship, this beautifully right order, Lordship, by the Lordship, that 5 pages, Lordship, I have given, there is a bunch, Lordship, in the top of the file, Lordship. Or Lordship, if Lordship wants to see the pages from the main record, but Lordship, there is a five pages bunch, Lordship, I have given last date, Lordship.
Yes.
I can give it again,
It's
Lordship.
order of the court.
Yes, order of the court.
Yeah, it's already there.
It is the,
Order under challenge.
yes, Lordship. It is the, it is the, I have given a bunch of papers, Lordship. Last date, Lordship, 5 orders, Lordship. Because Lordship, then Lordship not have to take all this, Lordship. Order dated 28/1/25. Order dated 10/2/25.
You find it out. Yes.
Lordship is getting 5 orders, Lordship, I have given. It is there in the top of the file,
it's
Lordship.
there. Yes.
That Lordship, the single document, Lordship, then Lordship do not have to take this. Or Lordship, if Lordship wants to see from the record, I'll show from the record. There is no problem. That 28/1/25 order is at page 1049. In Mizze case number 25/24, title suit number 21/24. Lordship, I have given it separately, Lordship. It is at 1049 of the record. Or Lordship can give, I can give another bunch of.
No, it's
Yes, it is there, Lordship.
this page, the order is 28.
28/1/25.
Yes.
It is in the bonds. The pagination is 1049, Lordship.
Yes.
Lordship, get it. So, Lordship, this is in the Mizze case number 25, entitled arising out of title suit number 2024. And there is an order of your Lordships also, and then that I'll show separately. This has been set aside, Lordship. That is why we're here. Today is fixed for necessary order. Learned Counsel R. Sonar for the applicant is present. Learned Counsel E. Taba and Mrs. J. So-and-so. The court on the previous date heard Mr. R. Sonar, the appellant, and B. Halder, respondent number 1 to 9, and B. Datta for respondent number 10. It is the contention of the Learned Counsel, Mr. R. Sonar, for the applicant that the recently concluded election of the All Nisi Students Union, hereinafter known as ANSU, was done so in a flagrant violation in the court order dated 14/11/24 and 21/11/24. He goes on to state that by not complying the court's order, the respondent had affected the outcome of the election, and that the non-compliance of the order of the court by the respondent has prejudiced the right of the appellant. He further submit that in compliance of the order dated 21/11/24, Lordship, it is serious, Lordship. Lordship will not believe it, but it is very serious, Lordship. Further submits that in compliance of the order dated 21/11/24, the Deputy Commissioner and the Superintendent of Police, Capital Complex, Itanagar, had also passed several orders and measures to ensure compliance by the respondents. However, the respondents in gross violence of those intervention conducted the election on various posts to the Students' Union. To further comment his claim, he also stated that two official election observers submit a ground report on 30/11/24 that the election were conducted in violation of the order dated 14/11/24 of the court and order dated 21/11/24, 24/11/24, and 25/11/24 passed by DC and SP Itanagar. As such, he asserts the prima facie of the present case is made out in favor of the applicant. Further, he submits that the illegal conduct of the respondent, he caused irreparable loss to the applicant. He continues submission that the point by adding the resultant loss because of the conduct of the respondent cannot be compensated in any manner or in any monetary terms. Further, on the point of the balance of convenience, he submitted that the illegal act of the respondent is evident and not granting the injunction would cause severe and more damage to the interest of the applicant than anyone else. Therefore, the learned counsel, Mr. R. Sonar, also submit that the non-intervention of the court would send the wrong message to the parties and to the society at large. What is happening, Lord? He then added the sanctity of the court's order, whether wrong or right, ought to have been followed by the parties unless intervened by the appellate court. To support his argument, he has placed in reliance in the case DDA versus Skipper Construction 1996 4 SCC, page 622 Lordship. The pagination is not there. He thus prays for granting of injunction in favor of the applicant. On the other hand, B. Halder, respondent number 129, submit that there is no violation of the court's order and that all the order or all concerned authorities were followed and complied with. He stated that the parties whom this court granted the injunction order dated 14/11/24 were no longer the members of the branch students union and that their matters were sub judice in the civil court at zero. And as such, they submit no case is made out in favor of the applicant. Further, P. Datta, appearing for the respondent number 10, also objected to granting of the injunction and submitted that the issue pertaining to the violation of the injunction order dated 14/11/24 does not arise on the part of the respondent number 10. He also perused the application and all other material placed along with it. I had also perused the judgment and relied upon by the applicant. From the perusal of the above, it is evident that was the specific direction to the respondent number 129 by the order dated 14/11/24 regarding the applicants therein to be allowed to contest in the election and the other party be barred from participating. The report of the official election observer, Lordship will take note of this. The report of the official election observer and the order passed by the Deputy Commissioner and Superintendent of Police makes it evident that the order dated 14/11/24 was not complied with in toto by the respondent number 129. The said violation was even after the several intervention by the said authorities. So, from the above, it is crystal clear now that the prima facie case is established in favor of the applicant. And as submitted by the counsel for the applicant, the non-intervention of the court could result irreparable loss by the applicant as the same cannot be compensated in monetary terms. It is seen that the applicant stands as losing his right, which otherwise would have occurred to him, and the elections were conducted in fair and proper manner, and allowing the other party to enjoy the fruit of the illegal act prejudicing right of the applicant would be travesty of justice. This right cannot be compensated by bestowing upon the applicant declaring the matter in his favor upon final adjudication of the suit as much as in later stage, nor can the applicant be compensated in monetary terms later. Thus, it is also evident that the applicants have made out irreparable loss in his favor. So, Lordship, prima facie case, balance of convenience, irreparable loss.
Injunction was granted.
Yes, Lordship, and the injunction, Lordship, you have to read in the next page. And Lordship, only few lines, Lordship, will get it, the whole
Yes.
thing. This court has carefully weighted the considering the harm that could be on their party. The injunction is granted in favor of the either party. The court is also not oblivious to the harm of the respondent faces the injunction is granted in favor of the applicant. At the same time, it is now also aware that the respondents placed themselves in the harm of their own doing. That is violation of the court's order dated 14/11/24. By an act of their own doing, they have also prejudiced the right of the applicant. As rightly opined by the counsel of the applicant, the respondent ought to have complied with the aforesaid order unless intervened by the appellate court. Non-intervention of the court in the matter would only legitimize the illegal act of the respondent by which the respondent number 10 has come to find himself in the position to begin with. It appears that the applicant faces more harm if the injunction is not granted in favor of the respondent. As such, in my As such, in my considered opinion, the applicants have succeeded in making out the balance of convenience in his favor. Resultantly, the prayer of injunction of the applicant is allowed. Now, Lordship will see what is the injunction. Line 3-4 line. The operation of the result notification dated 29/12/24 with respect to the respondent number 10, Lizen Gadi is suspended. Lordship will take note of this. The operation of the result notification dated 29/12/24 with respect to the respondent number 10, Lizen Gadi is suspended. Respondent number 10, Lizen Gadi is also barred from representing himself as president, All Nisi Students Union for 2024 to 2027. He is also barred from using any sign, seal, emblem, or any other symbol of their office of the union. He shall also refrain from exercising the power and function of the president of the ANSU. The instant order shall remain in force till the pendency of the main title suit. The instant measure case application so-and-so then dispose of with this order. This is an inter partes order, Lordship. After issuing notice, after filing objection, everything. It's an inter partes order. So this is the final order in the injunction application. Lordship, may please come to next one. I have given 4 orders, Lordship. Next order is 10/2/25. 10/2/25. So this is an appeal filed by the Lizen Gadi. This respondent number 10, Lordship. And the present respondent in this case is respondent number 1. In the suit, Lordship, is respondent number 10. He has filed the appeal. On 10/2/25, Lordship will see the instant civil misappeal is filed under 10443 so-and-so Arunachal Civil Code against the impugned order dated 28/1/25, what I have read just now, Lordship. Passed in civil so-and-so UPA in application number 25 or 24 arising out of title suit number so-and-so. Lordship, I will skip all this, Lordship, because all the provisions are quoted, Lordship. In the next page, Lordship, at page 1096, just next page. Or Lordship, I can read everything, Lordship. Because only the learned counsel has submitted that the impugned order was passed in an arbitrary manner, in a perverse manner, and prayed that this the impugned order. And that further, he submitted that stay can be granted under Order 41, Rule 5, although the instant appeal is filed under Order 43, in view of the provisions of Order 43, Rule 2. The learned counsel for the caveat C.P. Shona, they submitted that is the counsel for respondent number 1, that the caveat of respondent number 1 are the same person and was received by the appeal memo along with the annexer and the copy of the application dated 7/2/25. So we are on caveat, Lordship. So after hearing both the parties appeal, then on the other hand, learned counsel for the respondent number 1 has submitted that the impugned order is not arbitrary and is not perverse in any manner and prayed that the stay on the impugned order may not be granted. heard the learned council peruse the impugned order dated 21/2025, 28/1/2025. Seen that the impugned order of civil judge UP has relied.
Sir, next, this was fixed court hearing.
No, Lordship, it is rejected. On that interim is rejected. 41/5, not given, Lordship. Why, Lordship? Lordship was to read this 3 line only. The same judge. Lordship will see how he has U-turn.
In view of the above.
UPA has relied on the golden principle that is prima facie case, balance of convenience and irreparable loss for grant.
Rejected and disposed of.
Yes. So Lordship, he
Then-
said that all the principle is here. So it is rejected and here. Lordship, against that, the 1097 page, Annexa 4, that is a CRP number 15 of 25. Lordship get it. So this court's order, Lordship, is started at 1100, Lordship. Page 1100. Order dated 77/3/25. I'll not read everything, Lordship. Only first line.
Page.
Page 1100. 111 That Lordship, this bunch is there, Lordship.
Yes.
Yes. I have given that. That is it was written as 1097 page, Annexure 4 in CRP 15 of 2025. I have given that. Lordship. It is there. Bunch. In the bunch itself, I have given. 4 order I have given. Lordship, it is like this, Lordship. Annexure 4, page number 1097. It is from the paper book I have given this. It is like this. Guwahati, this High Court's order.
0703.
1097, Lordship. 1097, page 1097. Or I can, Lordship, get it?
No, it's in CRP 15.
Yes. CRP 15.
Yes.
Lordship, may please come to page 1100. 1100.
Yes.
Lordship, get it. So it is an order dated 7/3/25. Lordship, on the first paragraph. Heard Mr. D. Majumdar, learned senior counsel, assisted by S.K. Deori. My learned friend has appeared there, Lordship. For the petitioner. Petitioner is Legend Gyadi.
So this was against this last order.
Yes,
which you
last,
said,
that appeal.
10-2.
Yes,
So what had happened here?
yes, here, Lordship, all these discussed, Lordship, I'll go straight. What has happened, Lordship, in this case? Lordship, may please come to 1109. 1109, Lordship. Internal page 13 out of 15. Is paragraph 17, Lordship. Lordship, get it.
Yes.
Lordship. However, it is observed that while passing the injunction order, the learned trial court has discussed the 3 golden principles in detail, and the learned appellate court, while rejecting the pair of the stay, also noted that the trial court has thoroughly considered the 3 principles. Lordship, get it. Para 17, Lordship. At page 1109.
Yes.
Accordingly, the appellate court observed that no sufficient cause had been made out to grant the stay of the impugned order to ensure the quick resolution of the appeal fixed for hearing on 4/3/2025 with the intention to dispose of it. However, on 4/3/2025, the hearing could not proceed and the next date of hearing is 13/3/2025. That it is evident that the
Dismissed.
Yes, dismissed. Then Lordship matter goes back and the impugned order, Lordship. Now may Lordship can see this. This is also there, Lordship. It is Annexure 1, page 23.
Yes.
Lordship, get it. It is Miss Appeal number 2 of 25, order dated 24/3/25. Lordship, get it.
Annexure 1.
So this is the impugned order, Lordship. So in today's Lordship, this is the impugned order, Lordship. So all these paper, this is the impugned order,
So
Lordship.
appeal was dismissed.
Yes.
The appeal was
No,
allowed.
appeal was allowed, Lordship.
Okay.
So I am here before Lordship. Lordship, it's a long order passed, Lordship. The first few pages are all the parties' name and here. Lordship, I can read from page 36, paragraph 8. Finding is there. Page 36, paragraph 8. Heard all the learned counsel, peruse the case record, seen the impugned order dated so and so, so and so. Seen that the learned court below has mentioned and applied 3 golden principles of prima facie case, balance of convenience and irreparable loss in granting the impugned temporary injunction. Now it is to be seen as to whether the said direction in granting the temporary injunction of learned court below has been exercised reasonably and in a judicial manner or not. It is observed in the impugned order that the learned civil judge, Junior Division UPA, has stated that from the perusal of the above, it is evident that there is specific direction to the respondent number 1 to 9 by the order dated 14/11/24 regarding the applicants therein to be allowed to contest the election and the other party to be barred from participating. The report of the official election observer and the order of the deputy commissioner and the superintendent of police makes it evident that the order dated 14/11/24 was not complied in toto by the respondent number 1 to 9. The said violation was even after the intervention by the said authorities. So from the above, it is crystal clear now that the prima facie case established in favor of the applicant. Further, it is also stated that the impugned order that at the same time it is now also aware that the respondent has placed themselves in the way of harm by owing and doing violation of this court order dated 14/11/2024. From the above, it is observed that the learned civil judge Junior Division UPA in the impugned order dated so and so stated that the respondent appellant here has violated the another injunction order dated 14/11/24 of another suit in Mizze case number so and so in order to come to the decision in the prima facie case being made out by applicant in order to grant impugned temporary injunction order. In addition to it is seen from the order dated 9/12/24 passed in the learned court below in Mizze case number 39 of 24 and title suit number 17 of 24 at page 72 is so and so, that with regard to the allegation of violation of the said injunction order that is so and so by the respondent, said miscellaneous application filed under order 39 rule 2A section 151 so and so. There is earlier order violated, so there is an application filed under order 39 rule 2A that is pending. Now this court is aware of the principle of law that the contempt of violator of an order of the court should not be allowed to enjoy the return of the fruit of the contempt of the violation. However, the fact that the appellant have violated or not the injunction order that is so and so has to be decided after conducting the summary trial in the same suit by hearing and the other side and recording evidence, etc. So the finding is in total that
Unless it is established that there is a violation.
it is violation.
Rely on this.
Yes, that's the order, Lordship. And then accordingly in paragraph 10 said the allowed. And then and the finding is, Lordship, that there is no prima facie case. Lordship, it is paragraph 10. From the above, it is considered opinion of the court that the so-and-so UPA are in law stating predetermining that the injunction order number so-and-so is violated by the respondent and therefore prima facie case is made out to grant temporary injunction. The impugned order dated so-and-so, so-and-so. Hence, the court is of the considered opinion that the order dated 28/1/25 passed in so-and-so by Mrs. so-and-so is not just and proper and need interference. Accordingly, the order dated so-and-so passed in so-and-so case is set aside and quashed. It's a perverse order, Lordship. Says that the violation will be decided, then they will be punished, and that is the end of the matter. Now, Lordship, without without disturbing Lordship with all this paper, today what happened? Lordship may please come to page 1124. Additional affidavit filed by most of the defendant. We have filed an additional affidavit to bring forward that written statement. Lordship may please come to page 1124.
Additional affidavit.
One additional affidavit, Lordship. In civil revision number 35 of 2025. This for the delegate.
Is there additional affidavit? This one?
One.
Yes.
Now, Lordship, state come to 114. In the suit. 1143.
1143.
1143.
Yes.
Lordship, this is a written statement filed in the suit by the Electoral Enrollment Committee, who has prepared the whole electoral enrollment, Lordship. This person, and they are presently their respondent number 6 to 9 in this present petition, Lordship. In the suit, the written statement is filed by defendant number 5, 6, 7, and 8 in the title suit number 21 of so. This 4% is now in the present revision petition is respondent number 6 to 9. Lordship may direct come to page 1148. Para 8. Lordship, get it. Second paragraph, Lordship. Para 8, second paragraph. That the deponent state that while the nomination process was going on 15/11/24, the deponent did come to learn about the order dated 14/11/24, passed by the Honorable Court in Miss Case number so-and-so. Through the submission of the order and the various social media channel. However, since the nomination and scrutiny process were ongoing, the deponent were of the firm belief that the list of enrolled BSU, that Branch Students Union, and the school delegates dated 9/11/2024 submitted by the deponent will be finalized and voting process will be begin, because they are the main person, Lordship, to enroll the voters. Further, the deponent states that the deponent having a limited role during the whole election process of Anshu cannot directly interfere in the process, and as such, they had forwarded the issue to the Chief Election Commissioner. The deponent were told by the respondent number 1 that he being the final authority for peaceful conduct of the general conference cum election, and he apprehended that if the order dated 14/11/24 is implemented, it will cause immense hardship for the peaceful conduct of the election, and assured that he will convene a meeting to discuss the issue. The deponent herein have no role in the implementation of the order dated 14/11/24 passed by the Honorable Court. The deponent with the utmost regret submit that the violation of the order dated so-and-so passed by the Honorable Court in title suit number so-and-so was not by the deponent. 9. That as regards the statement made in paragraph 18 to 20 of the title suit, the deponent begged to submit by the Chief Election Commissioner on 25/11/24, which was come out to our notice after the minutes were drawn. As surprisingly, in the minute, the respondent defendant number 1 has decided to include the name of the delegates of APCYGTSU, that BSU, Lordship, I have said, Lordship, who are 54 in number, Lordship. This is the main crux of the matter, Lordship. The name of the delegates of 54 in number stated to be recommended by BSU of Anshu. Whereas it is stated that we as enrollment committee, while submitting the list of delegates, had excluded their name and left it to be decided by the election commissioner as there was various serious dispute and controversies with regard to the inclusion of their name.
So these are a matter of trial.
These are matter of pride. 100% Lordship. Why I am showing Lordship that there are hanky-panky and all that Lordship. Now he said that only violation will decide. Now Lordship, the right of the Lordship, that by violating the court's order, if you get something, you can reap the fruit. That's my problem, Lordship. By violation the court's order, by violation the deputy commissioner's order, by violating the superintendent of police order, then the sub-divisional police officer was beaten. All the government officials were beaten, Lordship. There is an affair by the deputy commissioner, Lordship. A search sheet is filed already on that. These things are going on, Lordship, in the name of the student body election, Lordship. All those government officials were beaten there to continue with the election. After the court order, and Lordship, not only that interim order passed, we have filed an execution, Lordship. I'll show. Please, Lordship, may please come to page 192. I'll go one there. Lordship, get the point, Lordship. There is nothing here.
These are-
Page
Madam,
1,
Sir, we'll fix the matter some other day.
Lordship.
Issues are very simple. Trial, what is the stage of trial? What is the stage of trial?
There is a order 12 rule 6 application, Lordship, because there is an admission, Lordship. Day after tomorrow matter is fixed. Tomorrow, Lordship.
You fight it out there. All these are matter of trial.
No. This is not matter of trial, Lordship. This is injunction, Lordship.
Yes.
Injunction, Lordship, no. Lordship, the injunction, if Lordship see, if by violating injunction, Lordship, someone continue, Lordship will allow them to continue.
No, that's why the appellate, lower appellate court has set aside.
No, Lordship. They have allowed the violator to continue.
No, that injunction order by the court has been set aside by the, of course, you are before this, against that you are.
We are before this court, so to get the protection, that is why there is urgency, Lordship, I am saying, Lordship. Otherwise not, Lordship.
So
Because Lordship, not only the injunction order, it is the prestige of the court, it is the prestige of this deputy commissioner, it is the prestige of the superintendent of police, then the SDP, all. Now, all these things are going on. A wrong message will go to the society that some people can do anything and everything under the sky. When there is court order, and the deputy commissioner has withdrawn the permission of the election, even then they continue. They said, no, I will go ahead. If Lordship will not protect that a wrong message will go to the society, Lordship. And the Lordship knows that the appellate court, role of the appellate court is circumscribed, Lordship. The Supreme Court is very clear from 1990 onward, even till date, Lordship, that in the injunction, Lordship, role of the appellate court is circumscribed, Lordship. And he has decided the whole thing. And he has put a new fact that there is a violation and the violation will be decided. Violation is punitive, Lordship. Lordship, for a moment, Lordship, think, if the violation is not filed, then what will happen?
No, if there is a violation, where is the recourse?
Lordship?
If there is a violation, what is the recourse?
Two recourse, Lordship.
They have taken
Report,
they have filed an application for injunction violation, which is pending for hearing.
Under section, under
39.
order
39.
39.
That is why the appellate court has said you have.
That is
filed
different.
an
That's a
application for
punitive
violation.
thing, Lordship.
That is yet to be decided.
We will give evidence and yet that will continue. That's a separate matter, Lordship. That has nothing to do with the injunction, Lordship.
But injunction was.
Lordship, the
based on
CPC is
violation.
very clear, Lordship.
See, your injunction is also ground on the ground of, is on the ground on the violation of the court order.
No, not only that. No, Lordship, that's the whole.
It's essentially on that.
There the appellate court is wrong. There the appellate court is wrong.
See, we're not saying that court's orders are to be violated. It should not be.
Yes,
It cannot be.
Then,
But then, when there's a violation, there's a recourse. Is not it?
Yes, record has come, all the
Not
deputy.
recourse. There's a recourse.
Recourse is
If
violation.
if you are alleging violation,
Yes.
there's a recourse to it.
Yeah, recourse
There's a provision.
we have filed.
Yes.
But in the meantime.
So that is the one which you will have to
No,
establish.
no, Lordship, we have not filed.
At this, for a moment also, I'm not saying that this is wrong or right. This is a right order. I'm not saying the impugn order. But so far as the violation is concerned,
Violation
to-
is a separate.
the understanding of, that's what I'm saying. Violation, if there's a violation, right? If there's a violation, allegation of violation, there's a recourse whether this is
Yes,
violated or
that
not.
recourse we have filed.
Yes.
We have,
It is pending.
yes.
Now, it appears that the injunction is essentially based on the violation
No,
allegation.
no, Lordship.
What are that?
No, Lordship. Then Lordship may please come the order of injunction.
Yes, that
It
we
is
have,
wrong.
you have wrote.
That concept is wrong, Lordship. It is not. It is not.
What was there?
Yes,
Just- Can you just recapitulate?
Yes.
What is the ground for injunction?
That is one of the ground.
One of the other.
is one of
What
the-
is the other ground?
Yes, I am saying.
That's what I'm saying. Essentially,
Yes, that is why I read.
essentially, it appears to be at the
That is why I
learned
read.
appellate court below has taken that point only.
That is why I read.
There's no other ground.
That is why I read. That is why I read the written statement filed by the all electoral officer and here that there are flagrant violation and all that. Right?
Well, you are relying the written statement to show that in the additional affidavit
Yeah.
that they have admitted that there is a violation.
Yeah.
But then violation is not by the election officer. I mean, chief election officer
Yes. Then,
or returning officer.
oh yes. Then,
That is a matter to be decided in the order 39 application, sir.
and in the meantime, that the
Let us
person.
kindly recapitulate it or first injunction order of the trial court.
So Lordship may please come to page 190.
Page
Lordship may let him either he will complete or me. I will complete. Lordship. If my learned
28-1.
pen wants to complete, Lordship.
28-1,
Page number only.
Lordship may please come to page 190.
1049.
No, 192. Lordship. This is 192 Jabutiga. Because the other puri hai. Lordship, get it. Page 192.
No, I am on the injunction order,
Trial
Yes.
court.
28-01-2025.
Yes.
This court has carefully weighed and considered the harm. 1051.
Yes. This court also not oblivious the respondent fact if the injunction is granted in favor of at the same time it is now ever the respondent has played themselves in the area of harm owing to violation of court order. That is one part. Yes.
What is the other part?
That is yes, that is what I want to say. So
What
that is why Lordship I want to go to the other cases. Lordship he has taken note of everything. Lordship in the top of the page 1051, he has taken note of this that the deputy commissioner, superintendent of police, everything. Lordship. From the perusal of the above, it is evident that a specific direction to the respondent number 1 by the order that is so and so regarding the appeal. These are there, Lordship.
That's what I'm saying. Essentially, it's based on the violation of the court order.
Lordship, it is not. So let us go to the original injunction order. That is at page 190. Page
190,
page 192.
190.
14. 14/11/24. Because Lordship has read the 28/1/25, Lordship.
Hmm.
Now, Lordship, this is 14/11/24, page 192. Lordship, get it.
Hmm.
What the 28/1/25 is referred. This is a separate suit, Lordship. The challenge is different. In this suit, Lordship, the challenge is different. In this suit, the challenge is different. Because in this earlier one, we have challenged that the election should not be conducted. And it should be conducted following the bylaw and everything. Lordship, may please come to page
What
194.
happened to that suit?
Lordship,
What happened to that?
pending? No, here only, this case only, this 39(2)(a), not that case, Lordship. That is why I want to show this. The 39(2)(a) is filed here only. And 39(2)(a) is a separate matter, Lordship. This has nothing to do with the title suit and the Mizze case. It's a separate matter, Lordship, under the CPC. Lordship, may please come to page 194, finding. Last part, Lordship. As such, upon being satisfied with the submission made by the petitioner plaintiff, I am inclined to allow the prayer of the petitioner plaintiff and direct that the operation of the notification dated 9/11/24, Lordship, get it. Page 194. Down below, Lordship. As such, upon being satisfied with the submission made by the petitioner, I am inclined to allow the prayer of the petitioner plaintiff and direct the operation of the notification dated so and so and so and so are suspended until further order. Further, the defendant, and in particular defendant number 1 to 8, are directed to enroll the name of the plaintiff. Page 195, Lordship. I am reading from original, Lordship, not from the typed copy, Lordship. Lordship, you can read the.
No, I've seen it.
Yes. Delegates recommended by the plaintiff number 1 and 2 in the list of delegates for the Anshu election 2024, and that they be allowed to participate and contest in the election. This is the order. Then, further, the plaintiff number 21 to 24 be allowed to file their nomination and contest the Anshu election. This is the court's order. Then, the defendant number 9 to 12 and defendant number 13 to 63 we prohibited to participate in Anshu election 24 as member of censor. There is a prohibition. Further, in the light on circumstances of requirement so and so, it is hereby dismissed as this strict adherence to this shall defeat purpose of the so and so. So this order is passed, and this is a specific order. So, Lordship, after that, Lordship, we have sent the matter to by all the authorities that this order is passed by the court. Lordship, may please come to page 227. We have filed an execution of this injunction order. Page 227. The execution is allowed. And execution, it is directed at page 228, Lordship. From down below, it is seen that this court, by the order dated 20/11/24 in Mizze case number so and so and Mizze case number so and so, directed the Deputy Commissioner, Chief Magistrate, Capital and SP Capital to enforce the order dated 11/11/24 in the aforementioned case. As such, considering the similarity of the situation, I am inclined to direct that the Deputy Commissioner cum District Magistrate Capital and SP Capital to provide assistance to the petitioner in the present case in ensuring the compliance of the order dated 14/11/24 in which case number 18 of 24 entitled suit number so and so. So this is an order passed in the execution of the injunction order. Then when this execution order was allowed, Lordship can see few things for Lordship knowledge only, Lordship from 240 onward. What is the things going on after the court's order? Page 240 to 242. How the persons were beaten up. Hmm? Now, Lordship, may please come to page 237. Page 237, Lordship. It's an order dated 25th November 2024 from the Deputy Commissioner. I will not read whole thing, Lordship. Now, therefore, Lordship from the down below. Now, therefore, in view of the above, the permission given to so-and-so, the Chief Election Commissioner Vice so-and-so, dated so-and-so, to conduct the election of 2024 of Nishi Anshu, as so-and-so Itanagar is hereby withdrawn with immediate effect. The permission was withdrawn by the Deputy Commissioner. And then the Superintendent of Police, Itanagar, is directed to enforce this order in letter and spirit. He shall ensure that all election processes stop during the time to enforce this order. Now, Lordship, please come to page 243. On 25/11, he has said, conducted the election. And when, Lordship, please take note of the last line of the first paragraph. At 9:15 p.m., 10:30, the Deputy Commissioner has passed the order. The Superintendent of Police has given the year. He continued with the election. Court's order, Deputy Commissioner's order, Superintendent of Police, the execution order, everything. No. At 9:15 at night, he has completed. Now, Lordship, the page 248. Sometimes, Lordship, the lawyer as a officer of the court to uphold the court's order, Lordship, sometimes we have to argue, Lordship. Yeah, because if someone do not follow the court's order, that will be dangerous proposition, Lordship, in the eye of law. In 248, Lordship, he has notified that these persons are elected. So this is a notification. Lordship, at 248, Lordship, get it?
I understand, sir, but that will be taken care of in the appropriate proceedings.
No, Lordship, no.
Not in the civil
Lordship,
division.
no, Lordship, wait. Lordship, this is in the other suit.
The court's order are, as you know, I don't have to say, but it's to be followed and complied with. But there's a proceedings in place.
And the person who will not comply the order, he will continue in the meantime.
No.
That's not the,
It's
not the
it's
Privy
not-
Council
it's not.
lordship,
That's why I'm
still
saying.
there.
As you know, there's a recourse to that. There will be appropriate proceedings.
Hmm.
And we're not sitting in the writ court.
No.
Like everything will pass in order. This is a civil revision petition.
Yes.
That's why I'm trying to
Yes,
indicate.
I know.
I understand there's a violation, appears to be a violation. There's a course and that recourse you have, availed the recourse. You have filed the order 39 application, which is pending.
And lordship, suppose,
Right.
lordship, for a moment, lordship, is it-
Now, primarily on the ground that there is a violation of the court's order.
No.
So the appellate court, essentially, I'm saying essentially, the lower appellate court found that since there is a violation, allegation of violation, which has been the section, application under 39 is pending, until the time that is decided that there is a violation, an appropriate order is passed, cannot just the pass the injunction order based on that. That is the issue. According to you, since the prima facie the clear cut violation of the court's order, injunction should be based on that. That is indirectly what you are trying to point out.
Yes, lordship,
mean,
if all these, no, yes, lordship.
See, that's
Lordship,
what I'm
if
saying.
all
I
these,
understand, sir. I agree. There appears to be a violation. Not appears, there is a clear-cut violation. But there is a recourse to that. So while sitting in this revisional jurisdiction,
no, that is
these
what-
courts
no,
are,
no,
the hands of these courts are tied.
No.
We're not sitting in a writ jurisdiction.
lordship will give me a
We
moment.
can
Lordship will give me a moment.
exercise
That is
our
why,
extraordinary
that is why,
power.
no, lordship will give me a moment.
Yes.
That is why I want to bifurcate.
Yes,
There's two suits. There is an order. That order was violated. Right? That order was violated, so we filed a violation application.
Yes.
Order 39 2A.
yet to be completed.
Now, lordship may please come
That
to
proceeding is yet to be completed.
that suit. Lordship may please come to page 248.
248.
Yes,
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 this is a result of the election.
yes, result.
That's what I'm saying.
Uh,
It's
so-
not prima facie. There is a clear violation of the court order. The court has injuncted and stayed the notification of election. They have gone ahead. Election conducted, result declared. All right.
Hmm.
So that is a matter of suits pending.
That is what I want to.
Number two suits are pending.
Mhm.
Different suits are pending.
Mhm.
Against the conduct of election
Mhm.
and the conduct of the election thereafter.
Mhm.
Then there's a violation of there's an injunction that the injunction has been violated. And for that violation, you have recourse to the order 39,
I have.
which is pending,
Hmm.
right?
Hmm.
Now, on that basis, the trial court has passed an injunction order. Essentially, I'm repeating again, essentially on the ground that there is a violation. Now, lower appellate court, according to them, has held that since the allegation of violation is yet to be determined, the injunction based on this violation of the court order cannot be sustained. Therefore, it's appeal has been allowed. Is not it? So you tell us what's wrong in this.
Yes, that is what I want.
Let us not go into the violation.
Yes, I'm trying, lordship.
So you come to that.
Yes, I'm trying. So this is this order 39
I'll- I'm sorry, sir. Sorry, I'll allow you. Let us be very clear.
No,
And maybe
yes,
my-
no.
maybe
I'm happy.
according to me,
No, I'm happy. Lordship has,
there are two things.
yes,
This is a civil revision petition.
yes.
No need to
I'll
indicate,
satisfy
no need
Lordship.
to indicate you,
Lordship,
you being a senior.
I'll
lawyer.
satisfy, lordship. It is
Number
not
one,
that
that
what
since
lordship.
this revisional jurisdiction,
There-
this court is taking,
Yes, yes.
sitting in a revisional
like-
jurisdiction,
I'll satisfy, lordship.
cannot act like a
After lordship will
mean,
come back, I'll satisfy.
court sitting in the writ jurisdiction.
Yeah, I'll satisfy.
There should be a distinction,
I'll satisfy, lordship.
maybe same person,
No, I'll satisfy.
different foreign functions,
Yeah.
responsibility.
I'll satisfy, lordship. Lordship, come. Please come back.
We'll see.
Sit.
I'm sorry, there's a issue in this matter.
Madam,
Otherwise, we would not have,
Madam. Lordship,
we'll just say not before the bench.
yes,
You make a mention,
Matter will be fixed next week, Lordship.
sir, I cannot take up, so we'll just say that not before this bench. You may make a mention.
earliest I was thinking of 17, but they have got urgency. So 10th I can come, Lordship. 10th.
No,
Oh, Lordship is not fixing any date.
I cannot fix it when I cannot take it up to the matter.
Lordship will just write one line that we have urgency, Lordship. Then the Chief Justice will place it next week, Lordship. Otherwise,
No,
that,
no, we'll say that not before this bench.
yes,
You may make a mention tomorrow, get it listed on Friday, fix it on next week, whatever.
Right.
Since,
right,
that's why
right,
I'm sorry, I should have set it up.
right, Lordship.
Otherwise, we
Right, Lordship.
would not have spent so much of time.
Lordship.
Making clear to my friends that before 10th it will be difficult. Every week my health doesn't permit.
No, that, I'm
I'm
not
just
saying
making-
anything.
No, I'm not
You
saying,
discuss what,
well, I'm not saying it to the court. I'm making clear to my learned friends because let there be clarity of
Hmm.
10th earliest I can come.
list this matter
Council will
be-
decide. that.
before any other
I
appropriate
may not
bench
come.
without
Lordship.
Man. Obliged, Lordship.
I'm grateful, Lordship. It's a presence hearing, Lordship.
Obliged.
Rather, I'm sorry,
No. It happens.
Sometimes it happens.
I missed out somewhere.
Much.
Item number 11.
My place, Lordship.
Yes.
Lordship, this matter may be closed because matter became infractions.
Mr.
Because the petitioner is non-APS. He has been summoned by the Tabang authority.
That has been dropped.
Yeah.
Okay.
Now in next Parvana, his name has been dropped out as
Okay.
some.
Mr. K. Lolet, learned counsel for the petitioner, submits that matter has become infructuous. List of Mr. M. Tasso, learned counsel, appearing on behalf of Mr. Aibab, learned counsel by respondents, is present. In view of the above, that the civil revision petition stands closed as in process.
Deeply obliged.
Item number 12.
Yes.
It seems, Lordship, nobody is appearing for the side. Other private, on the last occasion, Lordship, on 4/7/2025, the private respondent, they have filed for vacation of the interim order. And inadvertently, one of my colleague, he has failed to extend the interim order, Lordship. In fact, on that very day, IA was filed for vacation of the interim order. So may I pray that status quo on 26/6/2025 may be maintained, Lordship.
None appears for the petitioner on call. An applicant on call, Mr. A. Tatak, learned counsel for the opposite party of the petitioner, is present. Who submits that inadvertently there is no prayer for renewal for extension of the interim period interim order passed on
26/6/2025.
2025. Yes. Mr. Therefore, phrase for extension of the interim order, Mr. D. Loy, learned public prosecutor for the state is present. Present. No objection.
Lordship, for the extension of Lordship,
You will have to file application.
Lordship, in fact, on that very day, Lordship,
More so, the respondent has filed in for objection. Therefore, they may not,
Lordship,
maybe that's why they are not appearing. You file an application for extension. What's your, we'll consider.
yes, Lordship, the issue was on, Lordship,
No,
on the.
they have filed an application because there is no extension. Therefore,
Yes, only on the
they,
very day
they,
itself.
they
Lordship.
say that their purport is served. You file an application,
Lordship,
IA,
Lordship,
huh?
yes.
Lordship.
And you have not filed any objection also.
Lordship, in fact, this matter can be disposed of because this particular matter, the FIR, it's totally relating to contractual dispute between the parties.
I will consider that.
So,
The learned counsel, but considering that the no application is filed for extension. And there's no extension of the interim order dated so and so, huh? And no application is filed for such extension, praying for extension, although the petitioner has submitted that inadvertently no prayer was made for extension, the petitioner is at liberty to file appropriate application.
Lordship, Lordship,
This after a week.
Lordship, deeply obliged.
Item number 14.
May I please, Your Lordship?
May I please, Your Lordship? But in this matter, my lord, government respondent is yet to file affidavit.
We have to file affidavit, Your Lordship.
Heard Mr. S. Mohan, counsel, the petitioner,
Your Lordship?
prayer of Ms. Arbasarlan is still counsel for the 3 weeks.
Yes, 4 weeks, Your Lordship. I'm appearing for 1, 2, and 3.
Your Lordship, respondent number 4 has already filed the counter, Your Lordship.
Respondent number
4.
1, 2, and
1, 2, and 3. For the 3 weeks, huh? For the 3 weeks time is 4 weeks time is granted to file affidavit. It is submitted by
Counsel for respondent 4, Your Lordship.
you have filed the affidavit.
We have already filed, Your Lordship.
So and so submits that she has filed the affidavit. She has filed the affidavit on behalf of respondent number 4.
4, Your Lordship. Yes.
Yes, yes.
After 4 weeks.
Obliged.
Thank you, Your Lordship.
Item number 15.
Should be here also. I need some time to file affidavit.
What is the matter here?
Lordship,
What is the matter?
land allotment, Your Lordship, challenging the cancellation of land allotment.
Cancellation.
Yes, Your Lordship.
Mr. So your name is not there.
My name is there in Wakaratama, Your Lordship. It has not been reflected. in the
Counsel
court.
for the, on the prayer of, no, further 3 weeks time is granted to MS Arbasarlan for filing, for filing affidavit in opposition on behalf of the state.
Deeply obliged.
Item number 16.
Yes.
My last occasion, TRC was called from Special Court 0. The charge sheet was filed and the charge sheet copy was also served to the accused person. The next date is fixed on 11, 4/11 for CC. The accused is in the
So
custody.
you move an application before the trial court, charge sheet has been filed, then you come back, we'll see. Is it rejected by the judicial magistrate?
This is a POCSO case. 2 occasions the bail application was filed, but it was rejected.
On the ground of what?
Past bail application was rejected on the ground that 183 BNS victim statement was recorded by the magistrate. And second bail application are filed, but it was rejected on the ground that earlier bail application rejected. And again, second application was if granted, it will amounting to review the own order.
It's
That
not,
is-
it's on, there's no subsequent development.
Yes. That the second two application
What is
was
this
rejected.
first application rejection order?
Page number 14,
14?
page number 12 on what is a first bail application.
Hmm.
Page number 14 is a first bail rejection order. 1-4. The relevant portion is
Religious
there are
action will not be,
seven.
there is probability of victim being subjected to intimate coercion or undue influence by any person interest in outcome. This cannot be ruled out.
Operative person para 7, the ground of rejection why that 183 statement, BNS statement why not recorded. Only that ground, bail application rejected. And second bail application, the page number 15, and operative person is page number 16. Last para, page number 16, this.
No, it includes the, say, page 14 in the bars of completion and all the statement of victim under is yet to be recorded by so.
Yes.
Person interested in the, that's why the charge sheet has been filed.
Now chair says the charge has been
You
filed.
approach the, because basically it's a POXO,
Yes.
no matter your defense, although it will be matter of trial,
My
but then after the filing of charge sheet, you may approach. Otherwise, I'll be rejecting the bail at this stage.
in this case,
It's a POXO.
only allegation
You
is
went,
section,
yeah,
allegation is section 8 only. And
you went inside the house of the victim. And that too in a broad daylight.
my lord, there was one
No,
independent witness
allegation is very serious.
only.
That's why I'm suggesting you. Otherwise, I'll dictate the order, will dismiss the.
In that case,
We'll
I-
give you a liberty
yes.
so that if after consideration on merit, because charge sheet has already been filed, because that was one of the ground was that recorded, not ground, recorded was that the statement of victim is yet to be recorded.
Yes.
Is not it?
Yes.
So they may look into the statement. That would be better because you'll get a two opportunity. If I reject it today, better ends there. We'll go to the apex court. I'm not supposed to advise you,
Yes. Instead of
but then it's better.
instead of-
Looking at, that's why I asked for the bail order. Because
my
without the statement under section 1, this will be very difficult. Now there's a statement.
my lord, one independent witness is there. As per the statement of one independent witness, there is no such incident.
No, will not go. That's why, that's the reason you may approach. Because the better court would be the special judge who looked into it. Otherwise, at this stage, I'm not inclined to grant bail. That's the reason I'm saying.
Well, in that case, no problem.
Okay.
We will approach before the,
You withdraw it
yes,
and will grant you a liberty.
yes,
All right.
yes.
It's unnecessary, will be rejecting today and then. When you were arrested?
4 August.
4th August,
Yes.
3 months, 2 months.
About to 3 months.
Charge sheet has been filed.
Yes, cognizance has been also taken. And the next date is next month, 4/11, that is speaks for CC, consideration of charge.
You, 1 hour before that also, thereafter also you can file the application. Had Mr. T. Thorup, learned counsel for the petitioner. the applicant who submits that he may be allowed to withdraw the bail application with a liberty to approach the special court
0.
special judge, special court 0, Mr. MS El Hage Leonard, additional PP is present. Prayer for withdrawal is allowed. Accordingly, bail application stands. Dispose of a clause on withdrawal with a liberty to approach the special judge within brackets Fox 0, huh?
How like?
Item number
This
32.
is the scan copy. So need to send back, no? We need to send it back.
Today's morning.
No, this is original or a scan copy? Scan copy, though, no need to send it.
Item number 32. Bail 131 of 25.
Yes. Unlawful assembly.
Unlawful activities.
Activities, sorry.
Lordship,
The city was called for.
yes, Lordship. They have their own standing council, Lordship.
Who is there?
Lomak Prudu, Lordship.
Matter speaks today.
Yes, Lordship. Lordship, matter may be passed over for timing, Lordship. And take it. Item number 33.
May I pay all Lordship? I am on interim bail. Bail.
Hmm.
It's already appeared. My statement has been recorded.
CD,
Yes, that
case
was-
study have not received yet, Lordship.
From which police station?
It is not.
Alia.
Talia, yes, Lordship.
Aliha.
Yes.
Heard Mr. S.K. Devrilan, counsel for the petitioner. Applicant. MS El Hage Leonard, counsel for the Leonard additional PP submits and she is yet to receive. She has not received she is yet to receive the case diary. Therefore, fresh for listing of the matter after a week.
Lordship. After you.
Yes.
Whereas allowed list matter after a week,
Okay.
Yeah.
on which that the Leonard PP shall, additional PP shall produce the case diary. Scan copy of the case diary.
Yes, Lordship.
Interim
Interim
order passed earlier shall continue.
Apply.
Lordship.
Item number 17.
Where is it? Huh?
May I please?
Yes, why this has been listed?
My lord, last occasion, my lord.
You are supposed to take press steps.
Yes, my lord.
Service not complete.
Have you taken?
No, my lord. Maybe
For that, a week's time is granted to the London Council for the applicant to take press steps for service of notice of respondent number 2.
Yes. All right.
This after 4 weeks.
Okay.
MSL El Hage Lana additional PP is present.
Item number 18.
May it please your lordship.
Yes.
Lordship, steps upon respondent number 2 is not completed, Lordship.
Okay.
We are not able to get the correct address of the respondent, so
You get it? Further, For the 3 weeks, a week's time is granted to take process for service notice upon response number 2.
Obliged.
Yes, you're right. Learned counsel for the appellant is granted for a week's time to take process for service of notice. Mr. T at the London additional PP is present.
Obliged.
Pattern number 19.
Yes.
My lord, the leading counsel Tito Pu is not able to appear today because he has some personal issue, domestic problem.
Why this is listed?
For order.
Last
on behalf of
occasion,
Tito
only in June
Baba.
also you had some problem. Anyway. You are for?
Respondent to.
Any objection?
No objection, ma'am.
I don't know why this is listed for orders. There's nothing, no indication.
CD
Only-
was also returned, my lord.
Huh?
CD was also returned in this case.
Anyway, on the prayer of Mr.
Tipahi.
Learned Counsel appearing on behalf of Mr. T.
Tapata.
Topu,
Yes.
Learned Counsel for the petitioner. And prayer not being objected to by Learned Counsel, Mr. MS Swainso for respond number 2 and Mr. T. at the Learned simply list this matter after 3 weeks.
3.
3 weeks.
Obliged.
Item number 20.
May I, Lordship?
Hmm.
Lordship, here, the service is still awaited, Your Lordship. So
Await service report list
only,
after 3 weeks.
only praise that the
Mr.
service will be
Swainso,
given through
Learned Counsel for
registry,
the
then through
petition.
Bandardeva PS. Your
Ah,
service will be given through registry, then through Bandardeva PS.
so you will have to take press steps.
Yes.
Office note that it's so and so indicates that awards indicates that reflects that service report in this is still awaited. 2810, huh? Office note 2810. On the prayer of Mr. So and so, Learned Counsel for the petition, a week's time is granted to take precise steps for service of notice upon respondent number 2. Respondent number 2.
Petitioner.
No, service
Yes.
notice for respondent number 2.
Yes.
The officer
Which
in
shall
charge.
be routed through the
Officer in charge.
So the
office
officer
of
in
the
charge.
office of the public prosecutor.
The officer in charge, Lordship.
Through then not routed through the officer in charge, Bandardua.
Yes.
Bandardua police station. List after 4 weeks.
Obliged.
Item number 21.
Yes.
This pertaining to some monetary transaction matter.
IA is what? For what?
Lordship, I'm on the behalf of AK Singh, a respondent, sole respondent. He's supposed to appear today, but due to some health difficulties, he's out of station for health checkup.
AK
So-
Singh.
Yeah, and he'll be
You have not
filing.
filed objection.
Yes, he'll be filing objection.
You have not. You don't want.
No, we'll be filing objection in this.
What to do? Health.
Next.
Okay.
After
Mr.
after
Tisa,
2 weeks.
Counsel for the
And Lordship, there is a connected one matter, CPC 168.
MSR
168.
Learned Counsel for the Learned Counsel appearing on behalf of
AK Singh,
AK Singh, Learned Counsel for respondent number,
sole respondent.
sole respondent submits that due to, what the problem, AK Singh?
There is a
Health problem.
other matter also is connected. Kindly, the matter may be,
Madam, you want to just speak or you would like to
Yeah.
hear what the court wants?
no, after 2 weeks then. What?
What happened to AK Singh? Why he could not
Health,
appear today?
health issue.
Who
out of-
submits that due to health issue of Mr. Singh, he could not appear. Therefore, press for listing of the matter after 2 weeks.
2 weeks.
2 weeks. Prayer not being objected to by Mr. Tisha and counsel for the applicant list this matter after 2 weeks.
2 weeks. But I have one more request. There is a connected matter. Kindly, that matter may be clubbed
Yeah,
together.
It is also for condonation of delay.
But yes,
Hmm.
yes.
How it is connected?
How I don't know, but
We'll just take it up. Once it is condoned, then if the petition is listed for admission, then you make a mention. It's a condonation of delay.
yeah.
Thank you.
Obliged. Item number 22.
With legal aid counsel.
Well, here in this case, one issue is there, madam, very serious issue is there.
Hmm.
Here, your lordship, in main case, conviction has been challenged before this honorable court,
Hmm.
which was, conviction was upheld, and later on they prefer for SLP. And the SLP was dismissed, and again they prefer for review, which has been dismissed by the FX court. After that, they prepare this appeal under section 341, madam.
Hmm.
The 341 is not the jail appeal, madam. It's a different proceeding
Hmm.
for producing for allegation of producing, my lord, this false statement or false evidence, my lord.
Hmm.
But however, it is number a jail appeal. It cannot be a jail appeal. It's a appeal under 341.
Who is legal aid counsel?
Legal aid counsel D Sora perhaps is reflecting as D Sora, madam.
We'll change it. We'll appoint Jaya. You appear. There is a issue to be resolved.
Yes, madam. Issue is there, but
We'll just say, we'll appoint her today. You furnish the copy, papers, huh? Then on next date, we'll see.
yes, and my lord, the registry may be directed to furnish us the record or record of the court also, because we have only petition, no order, nothing has been given to us, madam. Only the petition they provided to us. No impugn order, madam.
Huh. Although, Mr. What is Mr.? Mr. D. Sora appears to have been appointed as legal aid counsel. How about right? He remains absent when the matter is called for. List of in view above. Miss Jaya Doji, then counsel is appointed as legal aid counsel. No, appointed as amicus. Amicus or what?
Madam,
Amicus.
legal aid counsel, madam. It came through your lordship, district legal service.
Appointed as legal aid counsel. Mr. Raised to furnish the relevant papers, including the memo of appeals to MSJ Learned Counsel, Jaya Doji Learned Counsel, as well as to Mr. T. Learned Additional PP. Huh? Okay.
My lord, in respondent also, my lord, the name has been reflected, my lord.
Who is that? Who is respondent?
It's reflected as C hearing some, my lord, the name.
It's okay, we'll see.
Yes, your lord.
Item number 23.
Obliged.
Yes.
I'm appearing for the respondent number 1 and 2 and 3. There are 3 respondents.
Heard MS.
I'm appearing on behalf of Entangel,
Your name, please.
Miss K. Nyora.
MSK, your London Council. Appears on behalf of MSN London Council for the petition.
Okay.
You're appearing for the first time,
Yeah, first time.
Mr.
T Nega.
Srinagar London Council enters appearance on behalf of all the respondents.
All the respondents.
Lower court, trial court record is received. List for admission hearing.
Yes.
After 3 weeks,
Yes, we'll file objection also.
it's up to you. CRP.
2
We'll
weeks.
list it after 3 weeks.
3 weeks.
In the May, you may file.
No.
We'll not record that.
Objection.
Matter number 24.
Mayor, Your Honor,
Yes.
I'm appearing on behalf of G. Lolan, Your Honor. On last occasion, Your Honor, this honorable
Mr. So-and-so, Learned Council appearing,
Yes, ma'am.
appears for respondent number, for Mr. G. Lolan, Learned Council by the petitioner. MS L. Hage, Learned Edition PP is present. Scan copy of the trial court record is received. Received list for admission after 3 weeks.
Your Honor, I have one request, Your Honor. Interim may be continue.
Interim order passed, earlier shall continue. Yes.
Much obliged.
Matter number 25.
My lord, if I may be allowed to withdraw the case.
Why?
Since, both the parties have settled.
Settle.
Just
What is the offense? Settle.
Yes.
Can we?
Yes.
Can we allow?
Yes, Lordship. It is between the
Heard Mr. So-and-so, Mr. So-and-so,
Techi Topu, my lord.
Techi,
Topu,
on behalf of? You are for?
G Riva, on behalf of G Riva.
G.
Toto
Ripa.
Riva.
Learned Council for the. Yes, what do you say?
Lordship.
It's a petition, he's withdrawing the petition only.
Yes, Lordship.
He's not withdrawing the case before the
Yes.
trial court.
Yes.
Trial court may be a problem, but
Yeah.
not here. Is not it?
Yes.
It's for quashing only,
Yes, Lordship.
is not it?
Yes, they settled their dispute, Lordship.
It's up to the, it's okay. Learned Council appearing on behalf of G. Riba, Learned Council for the petitioner. Press for withdrawal of this petition. Mr. D. Loy, Learned PP, and MS
Why Singhi?
Wishing Learned Council for the respond number 2.
Yes, Your Honor.
Are present, Mr. In view of the in view of the submissions, in view of the prayer, the prayer for withdrawal is accepted. Accordingly, the criminal petition stands closed on withdrawal. Yes.
Matter number 26.
Yes.
Your Honor, I'm for the petitioners.
The joint application, my lord, the offense is POCSO.
Hmm.
And your lordship, the record was called for, your lordship. However, we have not received the, my lord, the FSL report, and I've been informed that the FR has been filed, my lord. So record is updated. FR, yes, your lordship.
Final report.
Final report. But there are some materials, your lordship. So without closing this matter, your lordship may allow us to file the updated status of this case, my lord, along with the charge sheet, which a final report.
MS So-and-so Learned Council for the petition. It is submitted by Mr. T. Learned Additional PP. That final report has been, he has an instruction that the final report has been filed in this matter, in the matter. therefore pressed for some time to bring on record the state up to date,
Yes, status along with the final report.
updated status up to date,
Up to, Your Lordship, up to date, madam.
up to date status.
Yes, sir.
Just, accordingly, accordingly, that this matter be listed, prayer is, the considering above, let this matter be listed after 2 weeks.
2 weeks, Your Lordship.
So as to enable the learned additional PP to bring on record the up-to-date status. Yes,
Oblige, Your Lordship.
Your Lordship, I beg to mention item number 12. I missed it by unintentionally. We
12.
have filed wakalatama in main case today itself, Your Honor. And
12.
item number 12.
12 is already over.
Your Honor, I missed it by unintentionally.
What? You are for respondent.
I'm for respondent number 2. And Your Honor, in that matter, we would like to withdraw our IA number 73. And today itself, we have filed wakalatama in main case.
So you don't want to pursue the IA.
Yes, Your Honor.
You are for
Respondent number 2.
who has filed this IA,
Yes, Your Honor.
who submits that so and so
Yes.
for the applicant. You change that order, huh? Not change. That was in main case. We have not said anything on the IA, huh? Just find out. Learned counsel for the applicant submits that she has an instruction not to withdraw this, not to phrase this interlocutory application. Therefore, phrase for closure of the same. Please do.
Lordship, even I was not served to us, Lordship.
And then it shall also accordingly the interlocutory application stands closed as not pressed.
We need time for filing counter affidavit.
It's fine. Nobody is stopping.
Oblige, Your Honor.
Item number 27.
Yes.
Your Lordship. Your Lordship, service upon respondent number 2 is completed, Your Lordship. And it has also been learned that charge sheet has been filed. So TCR will be called for.
You're for respondent.
I am for the respondent number 2.
Yeah. Heard Mr.
J. Sring.
J. Sring, learned counsel for the petitioner. Petitioners.
Petitioner, sole petitioner.
Petitioner and Mr. Lee Loy, learned PP, and Miss MS J. Dozy, learned legal aid counsel for respondent number 2. It is submitted that during the pendency of this petition, charge sheet has already been filed. And we above, let the trial, scan copy of trial court records be called for. This after 3 weeks, 4 weeks.
2 weeks, Your Lordship.
2 weeks.
2 weeks.
From which place it is?
SEPA.
2 weeks will not do. Make it 3 weeks.
Yes.
Hello, Lord.
Item number 28.
Yes.
Today speaks for final hearing.
Who is for the petitioner?
One S. Sharma
Hmm.
and his company, Chinmoy Chakrabarti, Jaya Dipan Das.
Company.
28th. S. Sharma might be leading counsel.
So what is to be done?
Actually, on 21/2, 2024, updated CD was called for.
Yes.
And updated CD, here CD is available, one CD, dated 23rd March 2024, after that order. And herein it is said, IO says that this person is not involved in the present allegations, instant allegations. This instant allegation is regarding forgery, using a post document as genuine, by forging signature, they withdraw some amount from the government checkbook handled by the
Let us see.
regarding fraudulent transaction.
Yes.
Complaint was filed by the
What is to be done? That may be in view of this only. It has been culminated into final report. No
Final-
involvement.
no final report is yet.
No. It said this case lying pending for a long time, and hence the case was submitted by into final report.
Yes, then there must.
So what is to be done? We'll close this, recording your submission.
No. They petitioner counsel is absent today, so next that
No,
may
that may be a reason that they are not appearing. When there is no case against him, well, they should go for question. Huh?
I'll leave it to this court. As per my opinion, petitioner counsel should be present.
No
Has to be
appearance.
present. Otherwise, it may be dismissed on default. Because this is only a criminal petitions for quashing of effort.
We'll close. There's no case against.
Yes, that
Why he should go for questioning when there is no case? And it has been culminated into final report.
yes, but final report is not available with us.
You have cited it.
Yes,
Yeah.
that is a status report.
We'll close it.
It can be done.
No appears for the petition on call unnecessary. No, you just said non appears for the petitioner. Mr. Heard Mr. Jitado, learned additional PP. This petition has been filed under section 482 of CRPC 1970, praying for requestment of the FR, requestment of the Changlang PS case, requestment of the FR being registered, being Changlang PS case number 45 of 2019, under section 468, 471, 381 IPC 1816. Please stop. Where is the FIR?
FIR and petition, it's in page number
Allegation is,
35.
yes, allegation is what?
Allegation is forgery, that is 468, 471, 381. 381 is view of all the plaintiff, 381 is
Next para.
kept by clerk or servant of property in possession of the master.
On receipt, next para. An FIR was lodged by Dr. H. Tangjang, Medical Superintendent, District Hospital, Changlang, before the police officer in charge, Police Station, Changlang, alleging fraudulent withdrawal of money from APCMUHI's account number so and so SB Changlang, page 35, FIR. On receipt of, upon receipt of the said FIR, a case has been registered in Changlang PS case number so and so, under section so and so, so and so. The petitioner who was working as
Petitioner is dealing assistant of health department.
at the relevant point of time under the health department, particularly in the under the scheme,
District Hospital Changlang.
in the scheme has been inducted in the said case list of. Next paragraph. The Mr. G. Tadalanet PP by placing the status report submits that there is no evidence against the accused petitioner Sri Amin Hussain regarding his involvement in the fraudulent transaction, alleged fraudulent transaction list of. As per the FSL report, the signature and handwriting of the accused applicant, accused petitioner and other accused, co-accused do not match with the signature on the leaves of the check and authority letter seized from SBI Bank, Changlang. Mr. As there is no prima facie case against the accused applicant, accused petitioner, and others could be established. And consider and considering that the case was pending for long without any headway, the IO has submitted the final report. This stuff. Considering above, since there is no materials, public evidence, which could establish the involvement of the accused petitioner, at least fraudulent transaction in the case, and for that reason, the petitioner may not be, for that reason, the petitioner appears to have not pursuing the present petition. I deem it appropriate to close this one as there requires no determination for quashing the affair against the accused petitioner. Accordingly, the criminal petition is stands closed and disposed of.
Obliged.
This is what
Question number 32.
the status, copy of the status Swainer report placed by Swensu dated 23/03/2024 is kept on record and marked as document X.
My lordship.
Yes.
Lordship, the fact involved in the present case is that the alleged accused was arrested on 15/9/2025 while he was attending his normal duties at office.
You are working as what?
I'm a officer, a statistics officer, lordship.
How you are involved?
Lordship, that is why I am before this honorable court. Lordship, the fact of the case, lordship, since I am a regular government employee, lordship, so there is no question of my involvement in the present case, lordship. However, lordship, I have been arrested. Now, today is the 44th day. I am in the judicial custody, lordship. Over all these days, lordship, I have cooperated with the investigation, lordship. And all the devices, my personal belongings, like laptop, mobile phones, and even official computer has been seized from me, lordship. And lordship, there is no any other materials to be recovered and seized from me, lordship. And all those materials probably might have been sent for the forensic analysis, lordship. If, lordship, my involvement is there in the later stage, that it will the matter of trial, lordship. But as of now, lordship, I am denying all the facts, all the allegations of the prosecution, lordship, since my involvement is remote. So besides that, lordship, I fully aware of the fact that, lordship, this section, lordship, section 13 itself is not attracted in present case against me, lordship. Lordship, section 13 of the act says that punishment for unlawful activities, lordship. Lordship, in this case, there is no any proof that accused that he has wrote any letter unlawful or terrorist with a terrorist intention. No, lordship, even he had no link at all, lordship, with the so-called commander-in-chief, Sri Anthony Doke, lordship. The alleged person had no link, and he do not know who is Anthony Doke, lordship. It is the fact that in the year 2019, lordship, one gentleman visited the office of accused person along with the youth from his own village, that is Logomjini, lordship, for their personal work, lordship. But by that time, the alleged accused person did not know that the accompanying person was Anthony Doke, lordship. After some time, the youth from the villages told that the person accompanying him was the Anthony Doke. That was the only time, lordship, I happened to meet the Anthony Doke. So, lordship, in the fact, the present allegation is that there is some extortion note to some officers, government officers, served by the co-accused person, lordship. Even in that case, I did not involve, lordship. How I am implicated in this case, even I do not know, lordship. Only accusation against me is, lordship, that I have drafted the extortion letter, not for them, lordship. That is the only accusation, lordship. For that, lordship, the investigation has to substantiate some material proof to suffice their accusation, lordship. But I am sure that no such material documents and no such evidence is found from my possession, lordship. So, lordship, even in this act, lordship, there are certain embargo, lordship, under section 43D of the act, lordship, that the person accused of this offense is not entitled for the bail, lordship. That is well settled, lordship. And this section 13 is not comes under the chapter 4 and chapter 6 of the Act, Lordship. So my case may be considered in normal case like 439 of the CRPC laws. Even in the cases where this chapter 4 and 6 covers, the bail has been granted, and it is the
Where is the statement of the accused?
My lord, the statement of the accused is on page number,
Present accused,
page number 52, my lord.
52.
Yes, madam. I put a page mark, madam.
Hmm?
Page number 52, madam.
Okay. A pen drive was seized from you.
no, Lordship, it was not seized from my possession, Lordship. They have visited my office and they have at least to have
Very difficult, sir.
Lordship.
These are all elements. You may not be a member of this association, but you have some connection.
Lordship, for that I am ready
It's a
to
matter
face.
of investigation.
Yes, Lordship.
We'll
For
see.
that I am ready to face with the trial, Lordship. At least at this stage, since all the evidences, electronic evidences, has been seized from my
That is
possession, and there is no.
at this stage, that is enough to index in the prima facie involvement of you. You are not denying meeting with the Anthony Docket.
Yes, madam.
Lordship, it was in 2009.
Commander,
Lordship.
self-proclaimed commander.
By that time, Lordship, he
You
was
have
a
drafted
government.
a letter, extortion letter, addressed to the ALPA, commander of ALPA and the embassy, Chinese, Nepal and Chinese embassy. It's all against you.
Lordship, that is the
And the
accusation.
pen drive recovered from your office.
And my lord, this
You may be denying.
That is, Lordship, completely a disputed fact, Lordship.
It's okay. At
And
this stage, there is some materials against you.
Lordship,
You are not denying any connection with this person.
Lordship, since I am cooperating with the investigation from the day
It's
that
all
I
right,
arrested,
but it's
Lordship.
serious. These are all, I mean, cannot be taken lightly. You may be innocent, but materials against you.
No, Lordship, for that I am ready to face the trial, Lordship, and I am even ready to cooperate with the investigation.
The
even in the-
investigation at this stage is very difficult. There's a huge number of chain, huge numbers of members involved.
Lordship, what during the
And you
consideration
being
of
an
bail, what?
officer, what prompted you to indulge in all this thing?
No, Lordship, that is completely a disputed fact, Lordship, that I do not.
How you are related socially with Mr. Anthony Docket,
Lordship,
this so-called accused?
I have already mentioned in my petition that the one gentleman happens to visit my office in the year 2019 year.
You have not said so.
Lordship, I have already mentioned, Lordship.
No, you have
Statement is-
mentioned, but in your statement is you have directly met him.
Yes. He
He
used
came
to
to your office.
No,
You have
Lordship,
to
he
visit your house also.
He visited in my office, Lordship, by himself.
He
Lordship.
visited your house also.
That is disputed fact, Lordship.
No, your statement. Of course.
But by that time, Lordship, he was not a member, even a member of so-called unlawful organization, ban
But
organization.
you have drafted,
Lordship.
why you have to draft the
Lordship, the present case is of the extortion note, Lordship. And my meeting with this gentleman was in 2019, Lordship. And this is the case of 2025, Lordship. And so I am nowhere I am connected with the
this is
present
what?
case, Lordship.
Original?
My lord, yes, my original.
Lordship,
Very difficult.
in the cases, Lordship, where the Honorable Supreme Court has granted the bail to even in a offenses which is covered under section 4 and 6, Lordship. But my case is normal, Lordship. My case may be considered on normal 439, Lordship. Because while considering the bail, Lordship, the one aspect is to be very clear that
You
the
are suspended now.
yes, Lordship.
You are suspended now.
Yes,
Yes,
Lordship.
my
You are an officer.
But Lordship, even I am a father of 4 minor children, Your
I
Lordship.
understand.
Lordship, so there is no any flight risk for me, Lordship. Even in the event of granting the bail,
Yes,
Lordship, I am ready to cooperate every condition put forward by this honorable court.
As
Lordship.
straightforward by Mr. R. Ingo, learned counsel for the petition. Applicant, let this matter be listed on Monday. You try. Otherwise, I'm rejecting.
Lordship, at least
The Mr. El Kurdu learned special PP to produce the case diary along with status, up-to-date status on the next date fixed. Yes. Very difficult.
Or my lord, it may fix for tomorrow.
Lordship,
No.
tomorrow I may.
No, tomorrow. I'm not,
Otherwise, Lordship may consider it.
no, I am not inclined to,
Yes, ma'am.
I'm not inclined, to be frank.
Yes, ma'am.
That's why I'm fixing it
Lordship.
on Monday. Otherwise, I'll reject it now.
My lord.
Lord-
You expedite your investigation.
My lord, yes, my lord.
It's a serious thing.
Yes, my lord. Now
In my
the
case,
police
there is nothing to be investigated against me, Lordship, since I have
That's what I'm
surrendered
saying.
all my
My lord, there is
belongings,
also
Lordship.
allegation that one AK-47 is being smuggled.
It's yet to be recovered.
Yet to be recovered.
But that is one aspect of another aspect of the case, Lordship. Where I am being accused is only drafting of extortion note, Lordship.
Therefore, you have a connection, link with them.
Lordship, but
This, it appears that this unlawful, the association, these associations, they work this way only.
in that case, Lordship may fix the
If
matter
we
after-
find that privacy, your involvement, it's very difficult in such a matter. On Monday,
after a
alright.
week, Lordship.
huh?
After a week,
After a week.
yes.
Why?
Lordship, I have some personal difficulties.
They will give the fixed date.
Monday, okay, Lordship.
We cannot,
Third,
we cannot keep it pending.
yes, Lordship. Monday, third.
We cannot keep it pending. Otherwise, I could have finished it off rejecting it.
Lordship,
You
the
work,
offenses more.
no, you work more on the facts and the law.
Even Lordship,
All right.
And my lord, I have one prayer, my lord.
Huh.
In item number 30, my lord. Actually, it was mentioned without informing me, my lord. So that matter was fixed after 3 weeks, my lord.
Item
Item number 30, my lord.
30?
30, yes, my lord. So that matter will be fixed on 3rd of November, my lord, because I have taken consent from the opposite party also, my lord.
Item 30?
Yes, my lord, hearing matter. Hearing item, my lord. Item number 30, my lord. This morning, I was not informed about the mention, but when I contacted Miss Dangan, she was saying that's due to some illness.
No, that we wanted to know what happened to that taken up matter pending before the principal seat.
My lord, that matter is pending, my lord.
So you see whether this can be clubbed with this matter.
My lord, no, this is completely different matter. Because here, my lord, we are challenging the discharge order, wherein partially they have framed charges against accused person, but some
And okay,
sections.
item 30.
Yes, ma'am.
Same order, but list on Monday.
Monday.
You try.
Obliged.
Reply online.
I don't want to reject it.
Otherwise, in that case, Lordship may fix the matter after a week so that I can have more time for it.
No, you decide.
No, sir.
You give the date after a week.
My lord,
Ah,
no issue.
you give your,
11th.